New. It's the most wonderful time of the year. And I'm not a masochist, so I'm not talking about the holiday run up, and I'm not talking about pandemic spikes or the almost permanent midnight here that we have in the Northern Hemisphere, and in particular in The Hague today. I'm talking about the ADC annual conference, and I'm thrilled that we can all be here today because it almost didn't happen again, but here we are. And I'm Marie O'Leary. I am the current president of the ADC-ICT, and I have been serving this year with an incredible executive council committee and with a real outside of the box training committee. And we all started 2021 blissfully unaware that the end of this year would be so pandemic dramatic. We all blindly said, let's try an in-person conference. But after all, this is the 19th year of the ADC. And the annual conference has been something that I know that I appreciate, and we go into year after year. We get to see each other, we get to talk about things, and we missed it last year. And this specific conference was way too good to sit on a shelf. It could not sit there and wait to discuss for another year. So we moved it here online, where we have all of you here. Because we're spending this 21st year of this 21st century in this non-ending pandemic, we have to be online, but at the same time, we get to have people from all over the world right now. We've actually got to expand the base of the conference, so we will be able to have ideas and thoughts of people in far-flung lands, in far-flung time zones from where we usually congregate here in the, which is fantastic. But we also have the opportunity to reach out to each other and finally discuss some of these things that have been on our minds, and to really contact each other, connect, and say to each other, you know, I think that decision really was decided wrong, and here's my opinion why. But truly, we're far overdue to come together on this and these significant issues today, in particular fairness and international criminal justice. Reality or utopia? Fairness, what does it require? What are the pressure points of fairness? What can be done? And in this age of truthiness, how do we ensure that truth is truth and fair is fair? And I know I have a lot of thoughts on this hot topic, these hot topics that we're going to discuss today. And I know all of you do too. But we have a truly incredible lineup of panelists and moderators who are going to take us on this journey, guide us through these conversations, so we can all get to the true answers of what is fair and how do we do it. But before we jump in, I want to guide you through the day a little bit as far as online, how are we going to do this? First of all, we have 3 panels today. And as always, if you can keep the microphones off, if you're not speaking, that would be best for all of us, because we don't actually need the background noise to add any ambiance to the day. If you would like to intervene, you have a question in the course of the panel, just use your little electronic hand raise or type your question into the chat. If you want to find the little hand, they've now moved it into Zoom. If you go under reactions, so click on the dot on the bottom where it says more. From that, you can see there's something called reactions, which allows all sorts of emojis, but it also allows you to put your hand up. For anyone unfamiliar, there's my hand up, and that's what it looks like. In the same place, you can actually go ahead and lower your hand, as I just have now. That will let us know, and let the moderator know in particular, that you would like to take the floor with a question. When you are called on, you can take the floor, you can put your camera on, you can put your mic on, and you can ask that question to the panel. But please wait until you're called upon. Otherwise, we have a lot of people here and it could get a little overlap. In between the panels, we're going to try something new, because we were talking about the one thing we really miss about the conference, other than the great wisdom brought by the panels, is going into coffee and saying, hey, I haven't seen you in a while, or continuing that discussion that we've had just now on the panel. So we're offering 3 breakout rooms in between. It'll be the entirety of the first break, coffee break that we have in the morning, and the last half hour of the lunch break between 2 and 2:30. There will be 3 breakout rooms. Again, go to those 3 dots down there. Don't go there now, but you'll see where it says breakout rooms. That's where you'll be able to join a breakout room at the correct time. The topics that'll be there are continuing the panel discussion, general coffee talk or networking, And just feel free to go into those and see who you meet. They're not recorded, they're just for discussion. And we'll see, if people are interested. Totally optional, just giving a space for you to talk about things on the coffee break, especially if you're sitting there and you don't want to bother your housemates or pets with thought that you had from the last panel. If they're really successful, who knows, in the future or even today, maybe we could add a few more to the afternoon session. The hot topics that we normally talk about over coffee, such as the weather, why are politics so weird now, and what is TikTok? But for now, get comfortable. I can see you already are. It's a wonderful location that we've set up for today. Grab a pencil, paper, notepad, computer, whatever, to take some notes and write some questions down. And without further ado, I will hand over to our first panel and the skilled moderator of Marianne Carin, who will usher us into the day with the first topic. So I hand over to the panel and to you, Marianne. Thank you.
Well, thank you very much, Marie. I hope everyone hears me correctly. I'm gonna put my telephone in silent mode. And so good morning to all of you, and thank you for joining us to this conference, especially you early birds who have decided to attend the first panel. My name is Marion Carin. As you can hear from my accent, I'm French, and I have the privilege to be your moderator for the next 1.5 hours. Without further ado, please allow me to introduce our wonderful panelists, starting with Kate Gibson, that you can see probably on the gallery next to me. Kate is an Australian lawyer. She's been practicing before international courts and tribunals since 2005, and she has appeared before the ICC, the ICTR, the IRMCT, the ACCC, and the SCSL. Currently, Kate is co-counsel for Bosco and Ntaganda before the ICC, and she also represents Rohingya victims in the Bangladesh-Myanmar situation. Kate also leads the legal team of Paul Rusesabagina, who is charged with terrorism in Rwanda, and she is a member of the defense team of former president of Kosovo, Hashim Thaçi, before the Kosovo Specialist Chambers. Previously at the ICC, Kate, who is the co-counsel for Jean-Pierre Bemba, and you have probably heard of this case, who finished with an acquittal in 2018. Her prominent work extends to human rights and also transitional justice. And to finish, I have the privilege to call her my friend. Next, Stéphane Bourgon, that I have known for quite a while too. Stéphane is an international criminal defense attorney registered at the Quebec Bar. He's been practicing before international courts and tribunals for decades. You all know him. And in addition, he has a sound experience as a criminal attorney in Quebec, notably within the Canadian Forced Arms, as what you call in Canada, a JAG. Initially, he joined the Office of the Prosecutor of the ACTY in 1998, before being appointed as chef de cabinet for the president of the tribunal, who was the French judge, Claude Jorda. He's then represented accused before the ACTY, including the General Enver Hadjiasanovic. And he's currently lead counsel for Bosco and Ntaganda before the ICC. He's been lead counsel for Alfred Yeketom and for Maximilien Turinabo before the IRMCT. And our last panelist is Kairan Mohandas Menon. He's currently a Hardeman doctoral scholar at the Irish Centre for Human Rights and a legal fellow with the Guernica Centre for International Justice. From 2017 to 2021, he worked with the International Nuremberg Principal Academy. He has also worked on international law and justice related issues in India, Greece, and Spain. So as you can see, I am very well accompanied for this panel. Our topic for today is, can politics influence fair trials? And you know, this is a vast and highly contentious subject. I had prepared a personal anecdote to start with, But now that I'm thinking about it, I think that none of this will be as relevant as our panelist interventions. And that's why I would like to start by giving the floor to our first panelist, and I guess it will be Kate. Kate, is it you who starts? Yes. So Kate, please, we cannot wait to hear you.
Thank you very much, Marion. I'm happy to go first. It's 4 in the morning where Stefan is joining us from, so I think it's only fair that I kick things off. Hello, everybody. It's really nice to be here with you so early on a Saturday. I love the ADC, so I was so pleased to have been asked to be part of this panel and to speak alongside these colleagues and friends that I really admire. The question that we've been asked to consider today: can politics influence the fairness of trials? Yes, is the answer. Simple answer, yes, it can. Political agendas, political interference, political manipulation, of course, has the ability to turn a fair trial into an unfair one. And this is not just a defense position. This is not some controversial outlier defense viewpoint. Prosecutors talk about this. At the ICTY, the former prosecutor Carla Del Ponte was open about the fact that she thought political interference had really inhibited her work, from states, harbouring fugitives to interfering with witnesses. At the ICC, when the prosecutor Fatou Bensouda withdrew the charges in the Kenyan cases, she said this is because of political interference. The interference in politics means that I can't get the witnesses to cooperate with me in this trial. Normally, what we hear from international prosecutors is different. We hear politics and justice are separate. Prosecutors, we don't respond to political pressure. We're free from political influence. But the fundamental reality is, if you put that narrative aside, the mechanics of international justice, its actual functioning on the ground, the investigations, the witnesses, the access, the courtrooms, the evidence, all of that depends on cooperation from political actors. And when jurisdiction is essentially consensual, as it is at the ICC, it's just not possible to divorce justice from political agendas, where states like the US can put sanctions on the prosecutor, where defense counsel can be blocked from entering the territory of a crime base. Political whims of states dictate what we can do. And the question then becomes, for today's purposes, does that make the trials unfair? Do the political forces at play lead to unfair trials? I don't think political leaders pick up the phone to judges and say, this is how you should decide this case, or pick up the phone to prosecutors and say, this is how you should prosecute this case. But we have examples that we can't ignore of overt political pressure from states' parties and from states, putting obstacles in the way of international courts and tribunals when they're not happy with the way that things are progressing. So today, what I wanted to do was just give you some concrete examples of how politics is weighed in and, I think, impacted on the fairness of the trials that I've been involved in. So I was going to start with the Bemba case, although it seems really early in the morning to be talking about the Bemba case. But, and also you might be thinking, what am I complaining about? He got acquitted. But in reality, the political interference in that trial was staggering. We couldn't go to the Central African Republic. The defense team never went to the site of the crime base. we couldn't safely conduct investigations in country. So the prosecution is welcomed into the Central African Republic again and again and again, and we couldn't go. The significance of that was that we were examining witnesses blind. You know, in cases I've been involved in Rwanda and in Cambodia, you know every inch of your sites. You know if a witness is standing in this compound, they can't see what's happening on that hill. You know the dimensions of every prison cell in a prison in Phnom Penh. On the Bemba case, we hadn't been there. We hadn't seen the sites, smelt the air, seen the vegetation. What do the buildings like? What do the houses look like? Is it possible for Bemba to have landed a plane there where the prosecution says that he landed a plane? We couldn't see those things. And that's a huge disadvantage to us. And that impacts on the right of the accused to adequate resources to prepare his defense. But more than that, Mr. Bemba's troops, who were the alleged perpetrators of the crime, were a very small part, about 10%, of a much larger contingent of troops that was actually made up of 7 different armed groups, one of which was the Central African Army, which is now supporting the regime in power in the Central African Republic. And all these 7 different armed groups were wearing the same uniform and were visually indistinguishable. Of the thousands and thousands of pages of disclosure from the prosecution, there was no indication that anyone other than Mr. Bemba's fragment of that troops was committing any other kinds of infractions. No one else was committing crimes on either side. And not only is that inherently implausible, we know that it wasn't true because, human rights reporting at the time told us that it was untrue. And the prosecution aren't bad at their jobs. They know how to investigate. So why is it, after years and years of investigation, the prosecution didn't disclose a single document that indicated in any way that anyone other than Mr. Bemba's troops were committing crimes? That's political. That's interference. That affects the fairness of the trial. A complete lack of exonerating evidence. The prosecution isn't fulfilling its statutory duty to investigate incriminating and exonerating circumstances equally. It's conducting a one-sided investigation to collect evidence in order to be able to maintain its access to the territory that is controlled by the political and military adversary of Mr. Bemba, who wouldn't give us access. And then Mr. Bemba is acquitted in 2018 due to errors by the trial chamber in the assessment of evidence. And what's really interesting in terms of political interference was the reaction of the state's parties to that acquittal. The fallout from the Bemba appeals judgment was, horrific, frankly. It was very overwhelming. For me personally, it was too much to cope with, the attacks on Mr. Bemba, the attacks on the lawyers. But to give you one concrete example, the ICC's largest financial contributor is Japan. In 2019, Japan contributed 261 million euros to the operating budget of the court. And at the first Assembly of States parties, after Mr. Bemba's acquittal, the representative from the government of Japan got up and said the following, and these are real quotes, and you can read the speech, it's online. He said Japan was deeply concerned about ICC accused being acquitted because acquittals indicate the challenges we face in the collection and evaluation of evidence and performance in trials. And if acquittals are allowed to continue, justice cannot be brought to the international community. And he urged the ICC to take steps to prevent such unusual circumstances from happening again, and then made reference to the 261 million euros. It's not reading very far between the lines to get to, if you keep acquitting people, we're going to stop funding you. He said, if you keep acquitting people, then justice won't be served. What does that feel like for a new accused who turns up at the ICC? Does he think he's going to get a fair shake? Or is everything stacked against him? Will an accused feel like they're arriving at this sort of neutral temple of justice? Or will they feel that they're at a political institution? The ICC isn't alone here. I did 3 cases at the ICTR, 2 of which ended in acquittals. And the reaction of the Rwandan government to those acquittals was, sort of naked outrage. When my client, Justin McGenzie, was acquitted after 13 years in prison, 13 years, and then an acquittal, we should have a whole other panel on that. But after he was acquitted, the Rwandan government came out, and the prosecutor general, Martin Ngoga, said, and I looked this up last night actually, and it wasn't as bad as I'd remembered, but it's still pretty bad. He said, this is an extremely disappointing decision by the appeals chamber of the ICTR. Tribunals' decisions such as these are undermining its legacy. It's not ideal. Putting those statements from the government aside, there was a much more sort of sinister and pervasive aspect of political pressure at the ICTR, which was the obstacles that we faced every day in trying to get witnesses in Rwanda to cooperate with us. And not even to testify, but just to meet with us and talk to us on the defence. An accused has the right under the ICTR statute, and indeed ICCPR Article 14 has a right to be able to obtain the attendance and examination of witnesses on their behalf under the same conditions as the witnesses against them. That's a central component of a fair trial. There are only 10 fair trial rights guaranteed under the statute, and that's one of them. And so it's sort of up there, with presumption of innocence and the right to know the charges. We had no way of calling Rwandan witnesses before the ICTR without going through the ICTR Victim and Witness Unit, who in turn went through the Ministry of Justice, who in turn went through, for a reason I never understood, the Ministry of Foreign Affairs in Rwanda. So you could not testify in front of the ICTR as a defence witness without it being known to the government. And when I was co-counsel for the former Bourgmestre of Murambi commune, Jean-Baptiste Gatete, he had been accused on the 7th of April, on the first morning of the genocide, of murdering a very prominent local Tutsi leader. The prosecution's case was that he went with sort of hundreds of Interahamwe wielding machetes to her compound, went in, and he killed her in front of her kids and her husband, and then he took her body and put it in the back of the communal vehicle, this Toyota, and drove around town with it. A horrific allegation. And I was in Rwanda trying to find out more about, the killing of this woman who from all reports was this incredibly impressive person. And I found the neighbours, the people who've been living in the house next door. They were now in Kibuye, which is this, beautiful part of Rwanda on Lake Kivu, looking across to Congo. And I went there and I sat with them and I met them, and they told me the story of what had happened on the 7th, that, Interahamwe had come not in their hundreds, but had come to the compound and had killed this woman. And then my client, Mr. Gatete, came later and with the help of the family, put the body in the car and went to take it, to get it cleaned it and buried. So a different story from the prosecution case. And I remember when they were telling me this, that sitting there and this beautiful, and the sun came out sort of from behind this cloud and the lake went all sparkly. And I remember feeling sort of overwhelmed with, you know, truth and justice, and so happy that I was going to be able to, you know, bring this story to the tribunal and tell the judges. And I, you know, got my witness form to fill in their names. I'm like, I'm going to have to take photos of you. And they're like, oh, no, don't write our names down. You know, we can't be part of this case in any way. Please don't even mention that you've spoken with us to anybody. And I remember that on the drive back to Kigali feeling, you know, really dark, how you sometimes do in this job, knowing that what was going to happen in front of the ICTR wasn't going to be real. And of course, the prosecution witness, one witness actually, uncorroborated, came and went, and Mr. Gatete was convicted and, you know, is still in prison for that, among other things. Is that a fair trial? Can Mr. Gatete bring witnesses in the same conditions as the prosecution? Are his rights being respected? Or are they being impinged because of the political pressure inside the country and the inability of the population to speak out in any way that goes against the official narrative that's been put in place? Or their inability to testify without the knowledge of their government? ICL is politically charged. You know, it has at its core the political will of states. We all know this. If the question is whether this reality impinges on the ability of the accused to enjoy their fair trial rights, I think the answer is yes. And all that we can do as defense counsel is defend our clients in the most professional and vigorous and determined way possible to try and mitigate the impact that politics has on these cases, which is more than enough from me. So I'm going to hand back to our moderator, Marion, but just to say that I really look forward to receiving any questions and to discussing these issues, which I obviously find fascinating, with you further in the panel.
Thank you very much, Kate. That was extremely interesting. This is such a deep dive in what being a member of a defense team is, and our day-to-day challenges regarding investigations and meeting with witnesses, the simple possibility to meet with a witness. And that was extremely interesting. Thank you so much. Just in terms of organization, I would like to say two things. So Dominic asked me to inform you about the break rooms after the first panel. There will be 3 break rooms, one on coffee talk, which will be hosted by Danny, one on networking that will be hosted by Marie, and one on continuing with panel 1, which will be hosted by myself. And of course, if my panelists want to join, they are more than welcome. The second thing I would like to say is that if while going through the interventions from the panelists, you have questions and you want to communicate these questions to me directly so that I know that I can then give you the floor when the interventions will be over, please write in the chat, send me your question, and so that I can give you the floor directly after the interventions. So feel free to do that. And of course, if you have a question that arises after, you can still ask your question, of course. So now I guess it is Stéphane, our next speaker. Stéphane. Can you hear me? Yes.
Can you see me?
We can hear you and see you perfectly. So I give you the floor.
Okay, well, good morning, everyone. Great pleasure for me to participate in this panel. I think Dominic some time ago to address the influence of politics on the fairness of trials. And I see from Kate's presentation that the answer to the question is definitely yes. I'll try to bring to you the point of view of the practitioner, but practitioner both from as a member of ICTY, as more where I had regular dealings with the Security Council members. And then, of course, my experience defense, both at ICTY and ICC. I'm not sure how well the connection is, a bit far away. I'm not sure.
Just Stefan, if I may, do you have another device as a microphone? Because it seems that you would have a double microphone.
Can everyone hear me well?
And there is some lag, actually. So yes, Stefan, it seems that you have a double microphone. So if you could put one of them on mute, I think the problem is just there. Let's try it.
I will do my best. Maybe two. Okay. How's this now? Okay. So, as I was saying, I'll try to bring a point of view that cuts across my experience before ICTY, ICC, and MIC. Not to talk about also the Tribunal for Lebanon. I gave a lot of presentation over the years to various crowds. And most of the time I began my presentation by saying, what is the difference between what we do in The Hague and what happens in a domestic or domestic trial? And the difference in my view is twofold. The first difference is the size of the trials that we handle in The Hague. The size in terms of the number of charges, the size in terms of the number of events, the time period covered by the charges involved. All this makes the trials we do in The Hague different. Not because there's not big trials domestically, but very rarely do you see a trial that will cover a 2-year period. And that makes a big difference. And the second difference between what we do in The Hague is, of course, the mix between law and politics. And also because, as Kate mentioned, and I will insist on that, everything we do in The Hague, whether it's ICC or ICTY, depends on state cooperation. And once you are dependent on state cooperation, well, the door is influenced. Just to pick up quickly from an example, Kate was saying about Rwanda and ICTR. Let me relate to you one quick example. I have to be careful because I'm walking on a thin line, but I recall the moment I was assigned as chef de cabinet for Claude Jourdan, the president of the ICTY. It had been only a week when I'd been assigned there. Word that due to the chamber had acquitted Baraya-Guiza with prejudice to the prosecution. Paul Kagame had made a speech, and he basically said, well, if this is no longer playing ball. So, of course, as chief of staff, I bring the matter to the president of the court. And I say, well, Monsieur le Président, you know, maybe we have a little problem here. I have to be careful again as what I say, but what I can say is that there was no problem and the case was reversed. And because there was no way that ICTY, ICTR, in fact, could proceed with the Rwandan state not playing ball. I was privy to everything that happened, leading to that it was a request by the offended. And to me, from that moment on, I understood how important and how critical what the states could do to influence the process. Now, let me go quickly with let's look at a difference between ICTY and everyone here who are who study these cases will remember the famous Tadic case. The Tadic case, one of the grounds of appeal that was brought before Judge Kasese was the fact that the creation of the ICTY created by a political body, namely the Security Council. Of course, that ground of appeal was dismissed. And Judge Kasese in his ruling said, it is not because a political body creates a court that the political body will then exercise influence over that court, because there can be separation of powers. It was a very sound legal argument, but there was a lot of critics, especially in the academic community. People were saying this is not right because we are opening the door for political influence. Well, now let's look at the same thing. And of course, if you look at ICTY, the only way that the Security Council could influence was maybe by refusing, for example, a request when we created the ad litem judges, or some lobbying in terms of the budget that would be given to the court, or again, by doing a preliminary assessment of those who wanted to be judges at the ICTY. Now, the input of the Security Council over the ICTY was, in my view, minimal, although it was there. Now, let's look at the ICC. All the academics were so happy. Oh, now we have a real court created as a treaty with real, something that is really international law and something that will work. Well, in my view, they created a systemic problem for I see a message from Marion. I don't know what it says. Can you hear me or?
I was trying to be discreet. No, we would like to suggest you to maybe cut the camera because we have some slight connection problems, and maybe by cutting off the camera, it would make the whole connection fluid. If it's okay with you, of course.
Okay, I will try that. So,
thank you.
Is that better? that better?
Yes, thank you.
Okay. So immediately at the preamble, and the preamble says that the aim of the court is to shows that the creators of the court, the state parties, what they want is to put an end to impunity. Well, that should not be the aim of a court, but I will not go on this. Then systemic problem is complementarity. Complementarity was you only go in if a state is unwilling or unable. You hear me? I see that everything is frozen.
For any reason I don't exactly understand, it seems that cutting off the camera made it worse. But just go on. We can follow you. I think that's the most important.
Let me try something else. I will, if I can go here, maybe it'll be better. I've been having internet problems for the past 2 weeks. I thought I'd solve it.
Weirdly, when you talk about your internet problems, it went away. It was very clear.
Okay. Oh, now I have this one, and I'll try to cut.
I think we lost him. Let me check. Yes, we temporarily lost him. Maybe what I suggest so that we can keep going is that Kairan, would you be ready to take the floor?
Absolutely, yeah.
Yeah, so, and it's interesting because Stéphane gave a practitioner point of view and you are going to give us an academic's point of view. So we can really say that academics and practitioner points of views will be intertwined, like literally. Thank you.
Thank you. Am I audible? Well, thank you, Marion. First, I want to express my gratitude to the ADC-ICT, Dominic and the organizers for inviting me. It's quite an opportunity for me to listen and speak to such a distinguished array of panelists. So I'm hoping to provide an update on the developments that have been most important for universal jurisdiction proceedings in the last couple of years. And answer your questions by looking at the political and cyclical elements that may be relevant to understanding the status quo. I apologize if some of this is abstract, but I'm hoping that an update of this sort will still be useful and put further discussions in context. Now, before delving into the major recent proceedings themselves, I think it might be useful to reflect a little bit on the doctrine of universal jurisdiction. It could be argued that the progress of universal jurisdiction has been defined by cycles. In that, I mean, it has had periods of relative dormancy, at least in terms of profile, and phases of resurgence. And that understanding these cycles need a closer examination of various contexts, political and otherwise, of a non-judicial nature. This will surprise no one, as just the mere claim that there can exist a universal criminal jurisdiction, albeit for certain grave and selected crimes, is in itself one that evokes great political sensitivity and legal confusion. Now, Maximo Langer has identified certain factors that might affect or provoke a political reaction in the context of such proceedings. These include the profile of the defendants, the economic costs connected to the trials, and potential reaction from local political constituencies. If we take these together, perhaps unsurprisingly, it points to a reality that political considerations favor proceedings that are inexpensive. Expense here referring both to political and economic currency. a closer look perhaps at the Spanish experience over the last 3 decades, which has seen a marked change in the nature and the profile of the targeted defendants, point to both the cyclical ups and downs that have been faced by universal jurisdiction, as well as the impact of decisions of a non-judicial nature on the creation of these cycles. The 2014 decision by the Spanish Parliament that significantly diluted the provision of the nation's universal jurisdiction statute remains important in this context. What Langer also did was he surveyed around 1,050 universal jurisdiction related complaints that were received by public authorities in different nations. And he juxtaposed that with the numbers that went into trial and the nationality of the defendants. This revealed that in the case of 87 complaints brought against citizens of Rwanda, for example, 11 went on to the trial stage. In contrast of, let's say, 55 or 44 complaints that were brought against nationals of other nations, a grand total of 0 went on to the trial phase. On this note, it might be ideal to take a moment to reflect on the uniqueness of your universal jurisdiction as a doctrine that, on the one hand, is not dependent on the United Nations and multilateral frameworks for its existence, but on the other hand, needs to tread the delicate space between acting upon intangible and sometimes imaginary consensus that supposedly exists within the international community and state behavior that has the potential to be volatile based on international relations incentives. For this reason, any review of universal jurisdiction related developments that ignore the political components that revolve around it will most likely lead to incomplete conclusions. Now, none of this is to imply that what is being done today through universal jurisdiction proceedings is less important than what has been done before. It is merely to acknowledge that as we witness quite an extraordinary period in relation to such proceedings, acute political considerations will also play a major role in how this cycle will be judged. This is particularly pertinent due to the renewal of universal jurisdiction proceedings, partly due to more awareness, the establishment of specialized units within national prosecution and investigation agencies, and partly as a response to the existence of stalemates and resource-related issues in the international context. As for some of the proceedings that have been most relevant to the recent period, structural and focused investigations in Germany have led to multiple developments. Most notably, a judgment of the Higher Regional Court of Koblenz that was delivered in February 2021 convicted 2 Syrian officials belonging to the Assad regime's secret service of crimes against humanity, while another verdict from the Frankfurt Regional Court last week became the world's first verdict called that genocide was committed against the Yazidi people, while sentencing an Iraqi member of the Islamic State to life in prison. This prompted Nadia Murad, the Nobel Peace Prize laureate, to state that the German actions were, quote, not only raising awareness about the needs for justice, but also acting upon it, end quote. Another recent judgment from the German Federal Court of Justice dealing with the former officer of the Afghan National Army who was in German territory held that state officials do not enjoy functional immunity under international law in the case of international crimes. The judgment, while narrow in its construction, has been described as having the potential to be pioneering. Now, whether these proceedings will lead to the prosecution of higher officials, or whether they've reached a threshold that might invite political action, remains to be seen. Now, another major development saw the owner and chief executive of the Swedish company Lundin Energy being charged by Swedish prosecutors of complicity in grave war crimes committed in Sudan. The company officials have been charged with asking the Sudanese government to secure an oil field, despite understanding or allegedly choosing to be indifferent to the fact that such securing would have had to be done by force and in violation of international humanitarian law. Perhaps some of the following updates also reflect the distinct ability of universal jurisdiction to look backward and identify impunity gaps in relation to historical crimes and periods. This is a characteristic that may potentially allow universal jurisdiction to penetrate spaces and bring justice to issues that may escape the focus of international mechanisms due to time, resources, politics, and the complex wrangling that can tend to dilute international mandates. The Jesuits massacre trial that was held last year in Spain, in which an El Salvadoran colonel was convicted for his role in the murder of 6 Jesuit priests and 2 women in November 1989, as well as the recent indictment by an Argentine judge of Rodolfo Martin Villa, former minister of the Franco regime, showcases the possibilities of universal jurisdiction. The fact that the latter indictment was made despite a letter sent to the judge by 4 former Spanish prime ministers from across the political spectrum point to political factors that may play a role as the trial progresses. Moving on to non-judicial developments. In 2005, the Institute of International Law adopted a resolution on universal criminal jurisdiction with regards to the crime of genocide, crimes against humanity, and war crimes. The resolution contained the following excerpt, and I'll just read that. The jurisdiction of states to prosecute crimes committed by non-nationals in the territory of another state must be governed by clear rules in order to ensure legal certainty and the reasonable exercise of that jurisdiction. Now that may seem self-evident, but the reality is that 15 years later, the 75th session of the United Nations General Assembly and the 76th session of the following year saw states expressing their frustration in relation to the lack of clarity as to what universal jurisdiction truly signifies. This clarity will also need to aid the understanding of how such proceedings are supposed to interact with international courts and the principle of subsidiarity. The 76th session saw submissions on the application and scope of universal jurisdiction made to the 6th committee by 16 states, the African Union, the Council of Europe, the International Organization of Migration, and the Organization for the Prohibition of Chemical Weapons. Reading these submissions again point to the same issues from years before continuing to persist, with states expressing their concerns on the lack of substantial progress after decades of discussion and continuing to hold vastly different views on this theme. Further concerns also exist in relation to the fact that such proceedings are only ostensibly targeting officials from specific regions as opposed to others. The bright note, though, is that more nations seem willing to remove obstacles and incorporate universal jurisdiction provisions into their domestic law. This led to the 76th session preparing a draft resolution recognizing the diversity of views that exist between the states and inviting a working group of the 6th committee to be established for next year's session. This group has been asked to consider the following question: what should be the role and the purpose of universal jurisdiction? In relation to this question, and also to conclude, Gary Simpson, in his book, Great Powers and Outlaw States, Unequal Sovereigns in an International Legal Order, describes the international legal order as a product of the interaction between 3 distinct languages: the language of sovereign equality, the language of great powers, and the language of anti-pluralism. In some way, these cycles of universal jurisdiction also interact with these languages. To some degree, perhaps, this lack of clarity may be a reflection of universal jurisdiction's intrinsic decentralized nature and of having to be universal in an unbalanced world. So as the United Nations continues to consider the role and purpose of universal jurisdiction, it can only be hoped that the proceedings and developments that are defining this important and ongoing cycle will confront more hierarchies, and even politically high-cost proceedings will both come into fruition and survive. Thank you.
Thank you very much, Karen. This was extremely interesting, especially because it's true that we always foresee international justice in international courts and tribunals, but we do not necessarily think about universal jurisdiction. And that's clearly a part of the picture. And thank you very much for reminding us and making like this brilliant and detailed presentation. I would like to...
Marion, I'm there.
Yes. I give you the floor for the rest of your presentation.
Thank you very much. I will conclude in no more than 5 minutes. I was talking about, of course, systemic problems.
Take your time, please. Take your time. We have the time.
Okay, systemic problems in the, of course, the statute of the ICC. And I mentioned a little earlier complementarity, but first we need to look at, after the preamble, of course, we look at the possibility for a state party to trigger a case or ask the prosecution to defer a case to the prosecution. I'm talking, of course, about Article 13A and 14 of the statute. Now, the case that the example that comes to mind is that of Congo. Congo, as in my view, played the court from the beginning by using Article 14 to get rid of its opponents, whereas many of the problems in Congo rested with the government and not with the opponents. Now, of course, that is not to say that crimes have not been committed. That's not the point of view. But by having the state trigger cases or ask the prosecution to investigate, then that investigation cannot take place unless they have the full support of the state, namely Congo, in order to maintain, secure this cooperation from Congo. The only way that this can be done is by playing with Congo. And of course, not going or doing anything against the will of Congo. And from a fairness point of view, these cases are always, as mentioned, opponents of the regime. And it is not possible for the defense to obtain the witnesses because the witnesses know that if they come to testify in The Hague for the defense, then for all intent and purposes, their life is over. They will lose their job, their families will lose their job, or they might even face some more serious consequences. Now, that's direct influence over the trial process. And of course, we look at I mentioned earlier, the Security Council. Power has been given to a political body, not to create a court like ICTY, but to directly influence the work of the court by either deferring a case or asking for the prosecution to conduct or investigate in a state which is a non-party to the ICC statute. Now, that is direct political power given to the Security Council. More importantly, we know that China, Russia, and the United States are not members, are not state parties. So here you have the 5 permanent members of the Security Council who rule and who decide on these cases. 3 of them are not state parties. To me, this is a fundamental problem which proves that there is political influence. If not, these 3 states would be in. Now, we look, that's one way of systemic problem, and the other one is the Assembly of State Parties. The Assembly of State Parties is much more powerful than by the looks of it. The Assembly of State Parties can really influence the work of the court because, as Kate was saying earlier, the Assembly of State Parties are there for impunity and they do not want acquittals. And they've made this clear, very clear in their input on the work of the court. Let me use an example. The Kenya cases. When there was, we remember that 2 of the accused in the Kenya cases became president and vice president of Kenya. One issue at the time was whether an accused should be present for his or her trial. And by lobbying the Assembly of State Parties, it became very clear that the Kenya, whether that was right or wrong is not the issue, but that Kenya was able to influence the work of the court and the adoption of rules regarding the presence of an accused by lobbying the floor at the Assembly of State Parties. Now, more recently, Kate mentioned the consequences of the Bemba acquittal, because everyone you speak to is saying, oh, the court might not have some fair trials. They say, what more do you want? Bemba was acquitted and Bagbo was acquitted. and the Kenya cases fail, I mean, what better example can you have of a fair court when all these cases fail? Well, these cases fail not because of fairness. These cases fail because everyone agrees they were not put together the right way by the office of the prosecutor. Now, once you have these cases and that you have so many acquittals, then the Assembly of State Parties decides that it wants no more acquittals. So what do? They call for an expert review of the court. And of course, the president accepted, probably reluctantly, but did accept to have an expert review of the court. Now, if you are a defense counsel or if you are an outside observer of the court, you imagine that the experts will come in and they will examine the court for the purpose of making the court work better. But the result, and the judges of the ICC are about to adopt new rules, the result is no. The result is the expert review leads to ensuring that there will be no acquittals. And this is what will happen for the next 10 years or so, as the judges turn around, as there's a turnaround of judges who come at the court. And fortunately, of course, the judges change regularly. And maybe we have a chance of getting around the present atmosphere, because it's been created by these acquittals. And now it is very difficult to have any case before this court leading to an acquittal or leading to a fair trial. That's my point of view from practicing before the ICC. That's my point of view from, for another example, trying to get one judge from the largest contributing country, Japan, a judge who actually, I have to be careful with the words I use, but made it very clearly to her fellow judges. You approve the fact that I became a diplomat at the same time as I was a judge, or I resign and you'll be forced to start over the Busco trial. Of course, what was the result? Of course, the judges said, no, it's okay. What the judge did was perfectly fine. And of course, the trial proceeded. That's just one more of the example where you have indirect political pressure being exercised on the judges, on the prosecution, and of course, the end result is trying for defense counsel to do their job, get witnesses, and be able to produce the evidence, which sometimes is not being made available. I could go on with many other examples. Disclosure is definitely one of the examples. And what I say about disclosure is that the idea of redacting all the information, of protecting all the information, there's a name behind that. And that's important to protect certain information. But before the ICC, it has reached such an extreme that this, caused by indirect political influence, is making the life or the possibility to have a fair trial very difficult, if not non-existent. So what is the solution? Well, it's nice to talk about a problem, but what's the solution? Well, the solution to me is the turning around of the judges and the training of the judges, and a lot for the academic community to look at those cases. It was the same at ICTY. You look at the judgment, it looks the best, but go further than just the appearance of the judgment, read between the lines, and it stands out that the fairness is not always there. So the solution to me is that's one of the solution, but also I fear that the ICC will be marginalized in the future. The ICC is a body that is needed, and unless there is a serious realignment of the ICC towards making it a real court, then it will be marginalized. When the political powers don't know what to do with somebody, then they will feed that person to the ICC, and nothing else will happen. The ICC will continue to try to and put these persons under trial. I finished with the example of Congo and complementarity that I raised earlier on. What is the worst thing about this political influence, of course, going beyond the fairness of trials, is that the Congo government, by getting trials against its opponents and the prosecution being played, and by putting only these trials forward, well, now we go 20 years later in Congo, and the situation today is even worse than it was when the events leading to these cases took place. Not only is the situation worse, the people who are involved in these cases are the same ones who were not charged at the beginning, both from the government point of view and from other armed groups. So the ICC, which is supposed to put an end to impunity, well, look at Congo today. Did the ICC may accomplish its mission? Even if that mission is not the right mission for court, it failed miserably in my view, and Congo is a real example of this. So I would be much more inclined to favor regional courts where people understand the dynamics of the area. And the dynamics of the area, of course, you need an international component to these courts to preserve the fairness of trials. But that's a way to kind of protect trials from being influenced by governments or by the what Kate referred to, the political powers at play. Again, there would be many other examples I could give, but definitely it's an issue that is with us, that will remain. And to me, it's in the hands of the judges, and for the judges to realize that they are being played. Sometimes, not they, the judges, but the court is being played by certain provisions of the statute, and they have to be very, very careful with this, because it does have an impact on the fairness of trials. So that concludes my presentation. Thank you.
Thank you very much, Stéphane, for this very strong presentation, very determined, with extremely strong opinions. And of course, I encourage everyone in the audience to react if you have a reaction, to ask questions if you have questions, and I will gladly give you the floor. I have some questions for my panelists, and just before, I would like to react, because you both, Kate and Stéphane, spoke about this speech from the Japanese representative at the ASP in, I think it was in 2018. And I was also a member of a defense team who 1 month later benefited from an acquittal in the Gbagbo and Blegude case. And I can also concur to the frustration we felt when we heard this speech and when we read it. It was as if we felt we had contributed to undermine justice, where we think that we have taken a very direct part to fair trial, to the contrary. And I also believe that we did not really understand the content of the speech, and it remains a question mark for us, because we believe that acquittals are part of justice. They are a very clear and direct manifestation of justice. And so I can only concur to your surprise and the fact that we did not really understand what was happening at that time. Questions now. So this question is a global question and it is addressed to all of you. Do we know that for the purpose of transitional justice, accountability is a part of the process? Reconciliation is another part. There has been a ongoing questions before the ICTY of whether or not the ICTY was in charge of a reconciliation mission. Reconciliation is extremely political. Accountability is extremely judicial. So is it because we do not know whether reconciliation is a mission of international courts and tribunals that we still go under political pressure or political influence as you described them? And would it be a solution to separate strictly accountability and reconciliation, and to separate peace and justice? What do you think about that?
I'm happy to weigh in. It's a really interesting question, but I don't think that the ultimate goal should be the separation of reconciliation and justice. Ultimately, the purpose, one of the overriding purposes of meaningful criminal accountability is to try and bring communities back together. You know, communities that have been divided by periods of conflict or mass atrocities along whatever it was, ethnic lines, political lines, religious lines. The ultimate goal of criminal justice is that it contributes to a sustainable peace and to the reconciliation of a community. But we know and we see that that's only possible when the criminal justice process itself is not one-sided. Because when it is, it serves to exacerbate these divides rather than addressing them. Prosecuting one side of a conflict when there's been violence on both sides doesn't help and is actually harmful. So that's, I think, where we should focus rather than saying, let's put peace and reconciliation out of our minds. Because if we do, you know, what else are we doing here? The courts obviously have a very specific clinical mandate, which is to adjudicate cases, to determine in each case whether or not the prosecution has met its burden of proving each charge beyond a reasonable doubt. That's what it needs to do. But it does that in a larger framework, in a larger context that we can't be blind to. But what the international criminal courts have gotten wrong so far is not focusing on an even-handed pursuit of accountability, of prosecuting, you know, literally in the case of the ICTR, only one side. So if we keep doing that, there is no point to what we're doing because what we're doing is harmful. So we should keep in mind the bigger picture, but really focus on trying to circumvent the political pressures at play and help the communities come back together by an even-handed. You know, that's really idealistic for a Saturday morning. This is ideally what we should do. But I think we need to think idealistically and in these broad terms because what we're doing has a huge impact and is really important.
Thank you. Thank you very much, Kate. Anyone else want to react on that question?
Yes, if quick reaction. If you hear me?
Yes, you have the floor, Stefan.
Thank you. Many people would think, and I was a very strong believer in the prospect that without justice, there cannot be reconciliation. That was my point of view many years ago. That point of view has changed dramatically based on my experience, both before the ICTY, but mostly before the ICC. Because if I look at the ICC for the examples I mentioned earlier, Congo, there has been no reconciliation. And the situation is worse today than it was before the ICC stepped in through the Office of the Prosecutor at the request of Congo. So in some cases, in this situation, the first solution, in my view, is that when we speak of complementarity, and when a state is either unwilling or unable, the key to achieving both justice and reconciliation is for the Office of the Prosecutor in the first place to look and be able to look at all sides. If not, then there cannot be both reconciliation and justice. If that is not possible, then we are better off with a Truth and Reconciliation Commission, possibly leading to some cases. But by picking only some cases of some of the players, then you achieve no result in reconciliation, and the justice itself is challenged by influence of the government of that state. And that's, of course, a challenge for the ICC.
Thank you. Thank you very much, Stefan. Kate, please.
Can I come back to something Stefan said earlier, which I think is really interesting about what solutions would be, because sort of our want as defence counsel to rant and rave and complain, but it's nice sometimes to think about how things could be fixed. And I heard Stefan say that sort of the regionalisation or the localisation of criminal justice could be a possible solution to removing politics from the criminal justice process, which I think is interesting. I've heard her Honour Christine van den Weingart speak about the fact that the ICTY was created to remove this incredibly politically charged question of criminal accountability out of the region. She called it this hot potato that they took out of the former Yugoslavia and put in The Hague, and sort of put it in neutral territory to avoid this political aspect. So she was saying sort of the opposite of what Stefan was saying, and she was discussing it in the context of a debate of whether or not the ICTY had been successful in doing this, in taking this sort of political time bomb out of the region. Because that's the rationale, isn't it? That if you have these courts in The Hague or in Arusha or, you know, in Leichendam or wherever, then they can become these non-political institutions that sort of rise up above the divisions that are happening on the ground. I think that's nonsense. Put them wherever you want, you know, put these courts in the rainiest corner of Europe. That they don't exist in a vacuum. They rely on cooperation from states. You know, putting the ICTR in Arusha didn't remove it from Rwanda's political influence. Putting the ICTR in The Hague doesn't seal it off magically from political interference. But what it does do is remove the process from the affected communities and remove the process from the crime base and make it that every single witness, every victim witness has to travel internationally, which really increases the trauma as we see every day on the testifying process. And it breeds distrust locally. You know, who are these white judges in The Hague who are hearing these cases? It makes outreach harder, it makes understanding harder, it makes acceptance of accountability harder on the ground. And what does it really get us? Because we see it doesn't insulate us from political interference. And if you, just very quickly, if you look at the ECCC in Cambodia, which had a public gallery, a huge public gallery in Phnom Penh of 500 seats, and 160,000 Cambodians sat in that public gallery over the course of case 1 and 2 at the ECCC, and they watched the proceedings, and the journalists in Cambodia could all come and be present and be there, and it meant that the trials were, you know, on the front page of the papers, of the Phnom Penh Post, the Cambodia Daily. Everyone was talking about these trials, and the community felt involved, and they had an understanding, and they knew what was going on, and the acceptance of the ECCC as a tribunal was really, really high. as compared to the acceptance of the ICTY in the Balkans or the ICTI in Rwanda. Now, that doesn't mean that there wasn't political interference in Cambodia. There absolutely was. The Prime Minister Hun Sen basically dictated who could be tried. But if the ECCC had been in The Hague, it wouldn't have been able to avoid this political interference. So, is this a solution to try not to romanticize the physical removal of these international courts away from the regions themselves? Was what I wanted to say.
Yes, thank you very much. Thank you very much, Kate, and thank you very much for anticipating on my next question. But I see Judge Corner, I'm giving you the floor.
It's jolly kind of you because I'm not on this panel, but obviously I was fascinated to listen to this. And I really do want to come back on two things because I think it's really important. Firstly, because Kate's point about the trial, the ICTY trials being in The Hague and not in the former Yugoslavia. I don't know whether Kate remembers, but I certainly do, what the atmosphere was like in Bosnia, Croatia, and mainly in those two countries, and of course Serbia. It would have been absolutely impossible to hold trials, to get the witnesses there in the circumstances that prevailed, the aftermath of the conflict, which is still going on, as we can all see from what Dodik is doing, would have made it impossible. Witnesses wouldn't have come to court. So appreciating all, and I'm not in any sense trying to detract from any political influence that everybody's been talking about, but there was a real and practical reason for that as far as Yugoslavia was concerned. Second, can I get back to Stefan's point about the expert review and his assertion that it is designed entirely to prevent any further acquittals taking place at the ICC. It is designed, and we, the trial judges, are putting into effect to make the procedures fairer because they are more consistent, so that all trial chambers have the same method of admission, for example, or submission, whichever you choose, of documents. It is looked at all aspects of the court in order to try, as I say, to bring some kind of consistency, not to stop acquittals, but so that when there are acquittals, as there undoubtedly will be, because I agree that an acquittal is the sign of a proper and fair justice system, they will not be acquittals which are, as many of the academic commentators have said, difficult to understand and creating difficulties in the application of law. So you won't be surprised to hear that I strongly disagree with Stefan on that. So thank you very much for giving me the floor.
Thank you very much, Judge Corner. Actually, I was hoping that you would take the floor because I anticipated that you would disagree, and it was extremely important to have your point of view and your reaction. Thank you very much. Stefan, do you want to reply maybe?
Yes,
you want
absolutely,
to seek leave
absolutely.
to reply?
I've known Judge Corner for a long time, and I have the utmost of respect for Judge Corner, and I agree with what she said. Of course, you mentioned my assertion that it was designed for the purpose of what I wanted to say, and maybe it's the English language. It's not an assertion that it was designed to ensure that there will be no more acquittal. I said the aim of the expert review, the manner, the reason why it was launched, it was requested, it was as a reaction to the number of acquittals. That's what I meant to say. Now, once it was triggered, of course, I would have liked if the experts would have given more time to listening to what the practitioners had to say. For my part, I know that the defense at the ICC, we had a session of 1 hour planned with 3 of the experts, and in the end, it turned out to be a 15-minute session, and that was it. Of course, we could have put in writing our observations, and it was open to us to do that. But when you are conducting and you are in the middle of a trial, it's very difficult to take the time and to write a paper. And I would have liked to have more time with the experts to explain to them the point of view of the of why this what needed to be reviewed at the court. Because you mentioned, Judge, the issue of consistency, and that is, in my view, one of the most important issues, in that the manner in which trials are conducted from one trial chamber to the next is not the same. But this is not new. At ICTY, there were some changes from one trial chamber to the other. But at the ICC, it seems to be much more pronounced in terms of how judges are allowed in each of their chamber. The deference given to the trial chamber appears to be much more, and there are significant differences. If by having the expert review leading to more consistency, I could not agree more, Judge. This is definitely what is needed, so that there is an expectation of what you will have in a trial. And of course, my comments might appear a bit strong, but at the same time, when I look at the case I was in, a case that lasted for so many years, and it appeared to be that this was the case where the prosecution was trying everything new because they knew that the judges would go their way. And many of the changes that were brought to how to run a trial, there was a marked departure in the case I was involved in from previous practice. And that, of course, made our life difficult, and in my view, affected the fairness of the trial. Even though there was an appellate review, and I have to say that now I have nothing more, I have no further avenue to look at the fairness of the trial I was involved in, but it continues to haunt me, and that was never the case before. I always thought in my legal career that once the appeals chamber has spoken, this is it, and you live with the result. But now in this case, I must say that I have very much a lot of difficulty living with the result of that trial, which I think is because there had been acquittals before, and I believe that Mr. Taganda was never given a fair chance before this court.
Thank you, Stéphane. Judge Corner, if you want to reply, please.
No, I understand Stéphane's point on Ntaganda, but I don't think the same. I just wanted to make sure that everybody understood, and Stéphane's corrected it. I cannot comment on what he says the aim of the expert review was. As I think everybody knows, I've only been here a few months. But what I wanted to get across was that what it certainly in terms of trials, its aims should be seen as laudable by all sides.
Thank you. Thank you very much for your intervention. Thank you to all of you. It is now 11 a.m. So I guess we have to move to the break rooms. Dominic will confirm whether I am correct or not. Oh, sorry. We have one person who wants to react. And so it's Cecilia. So Cecilia, please, I think we can take a few minutes to a few more minutes. Please, Cecilia, you have the floor.
Thank you very much, Marion. Thank you, everyone, for this fascinating interventions. It was really, yes, brightening my morning. I just wanted to highlight a very specific point that I think also deserves attention. We have spoken about the impact of political interference on the rights of the accused, which is essential, of course, but I think there is another aspect that is interesting. It's how also political interference allows the ICC and international tribunals to fail victims of the crimes that aren't politically convenient to prosecute. And the case that I'm most familiar with on my end is that of Syria, which is not at the moment prosecuted before international courts and tribunals, but may very well be in the future. And we have seen from the outstart the disproportionate amount of attention paid to the crimes committed by the Syrian government. And as a result, leaving aside thousands of victims of other alleged perpetrators, and creating a really a significant gap in the justice outcome. So I think when we talk about political interference and the fair trial, yes, the right of the accused is paramount, but there is also the right of the victims that can also be impacted negatively by this kind of political interference. So that's just what I wanted to highlight. And thank you very much, everyone, for your interference, your interventions today.
Thank you very much, Cecilia. Maybe one of our panelists would like to react to your statement about the fact that the rights of the victims could also be affected by political interference. Kate.
Yes. The interference of states doesn't just impact on the rights of the accused to a fair trial, which was the point of this morning's panel. It absolutely impacts on all aspects of the justice process. You know, very strong, strident language coming out in response to Karim Khan's decision to deprioritize and prioritize certain aspects of the Afghanistan situation that civil society decried as being the influence of politics, pragmatism, you know, covering for political interference, and that this was letting down victims of you know, powerful states who have somehow managed to work their way in. You know, Amnesty International came out and said that decision is unfathomable and should be reconsidered, which is not the view held by everyone. Some people were applauding his stance and saying that the decision that he's taken is a reasonable one, because then at least some trials or investigations will proceed. So, you know, regardless of the community that you're speaking from or the angle that you're approaching this from, the influence of politics is impossible to divorce from international crimes. That's, you know, that's where we are. And, you know, Judge Corner is exactly right that in the early days of the ICTY, although I don't remember them, but it wasn't possible for Yugoslavian victims, witnesses, perpetrators to walk into courtrooms on the ground. The situation was way too politically charged. The point that I think we've made today is that, are we right to say that simply by removing these courts from the affected communities and putting them somewhere else, that we seal ourselves off from any sort of political interference, which was the question that Judge Van den Weingart had at the time, and one that I don't think is realistic, because we see every day in our work as practitioners in front of these courts that political interference weighs in on many different levels. And that is despite the professionalism of defense counsel, professionalism of legal representatives of victims, professionalism on the part of members of the bench, professionalism on the part of the prosecution. At its core, we are an area of international criminal justice that relies on the political whim of states. And the more that we're alive to that, I think the better. The more that we can have discussions like today's, I think the better. And we can try and find ways to bravely mitigate the impact of politics on the work that we do, which is at its core really important.
Thank you very much, Kate. Yes, I will now invite you to move to the to the break room. Sorry, I would not like. I don't want to be seen as advertising for my break room, but I still have questions for our panelists. By the way, I have a message for Chiara Loiero, if she's still here. Yes, she is. Chiara, you tweeted yesterday a report from Amnesty International. I think it was you. If you want to come to the break room and bring this report to the discussion, I think it is very relevant to the budget of defense teams, to the means given to defense teams to help in the process of justice. As a conclusion, I would like to thank you all for attending this first panel. It was really great to have you. Thank you for the questions. Thank you for the reactions. And maybe I will give the floor to Dominic or to Marie to check how we can move to the break rooms. Dominic, Marie, Dominic.
Yep, good morning, everybody. Oh, Marie's there. Yep, you can just join the break rooms at the bottom. You should be able to see that there's 3 rooms. And if you click on them, you should be able to enter them until 11:30 when the next panel is due to commence.
I'm going to be your moderator for this second session, which I am very much looking forward to, and I hope all of you are. We are going to be talking about how faulty evidence can fail justice. This is, of course, an issue that affects all of us, regardless of where we're practicing. But it is also an issue that has particular challenges as regards international criminal courts. For example, the difficulties in getting witnesses to come forward in high-profile trials, the remoteness of investigations, and difficulties of cross-cultural communications, as well as straight-up linguistic issues. The absence in some of these jurisdictions of any real law enforcement powers of the courts to be able to compel the production of persons or information, and the reliance on evidence procured by third parties. And there are also, as we touched on briefly in the last session, the realities of accommodating different legal traditions among the bench and the parties, which we are slowly trying to get a grip of at the international courts. So it's with the assistance of our esteemed panelists that we're going to try to get a grip on some of those issues. So we have, first of all, speaking Judge Joanna Corner, who is currently a judge of the ICC, where she's the presiding judge on the Abdel Al-Rahman case. Prior to joining the ICC, she was a judge in the Crime Court of England and Wales, and she has also previously spent 8 years as a prosecutor at the ICTY, where she was on cases such as the Stanisic and Juplin case, the Virginin case, and the Talic case, and the Stockage case. And today she is going to be speaking to us about insider witnesses. Our second panelist will be Wayne Jordat, QC, who is an expert on international humanitarian law and human rights law, and the founder and managing partner of Global Rights Compliance. He advises governments from across the globe on international legal compliance, including the governments of Ukraine, Bangladesh, Libya, Serbia, and Vietnam. As a practitioner, he has represented parties before all of the international courts and tribunals and will be speaking to us today in particular about his experience at the SCSL, the Sierra Leone Tribunal. Next, we will have Professor Felicity Gary, QC, who is both a practitioner and an academic. She led the appeal in R versus Joby at the UK Supreme Court. For those of you who don't know, that is now the leading case on joint enterprise in the UK. She has published widely on international and transnational crimes, including from a feminist perspective. And she will be talking to us today about the evidentiary regime at the extraordinary chambers of the courts of Cambodia. And then finally, we have Melinda Taylor, who is currently acting as the Assembly. I will continue. She has advocated continuously for equality of arms and fair trials before the ICC since April 2006, which is when she was recruited to set up the Office of Public Counsel for Defence. She also worked as a researcher for Antonio Cassese, the former president of the International Criminal Tribunal for the former Yugoslavia, the ICTY, and she is an officer of the IBA Human Rights Committee. She is also co-founder of the Yazidi Asylum Project and teaches international and regional human rights at Leiden University College. So just before I turn over to Judge Corner, a last word about housekeeping. Each speaker will be talking for about 15 minutes, and you can, as previously discussed in the last panel, just put your questions into the chat stream or use the hand raising function on Zoom when we get to the Q&A section, and we'll be very happy to take as many questions as we can. So without further ado, over to you, Judge Corner.
Yes, Annie, thank you very much. Good morning, everybody who didn't hear me intervene on the last panel. Firstly, can I say it is a great honor and indeed a privilege to be asked to speak to the Association Defence Council, although I have had some dealings with it before through advocacy training. What I'm going to talk to you all about today is insider witnesses, and I've got a short PowerPoint which hopefully, if I can share the screen, should work. Yes. Right. Because of the limited time, I'm going to whiz through, I hope, some of these slides and add a few words. I decided the simplest thing to do was to look up from the website of whatever the ICTY is now called. It was the MICT, it's something else now, their definition of insider witnesses. And you will see that it starts with a preamble, and then it defines them as persons who are close to the accused called insider witnesses, can provide the court with evidence about their actions and state of mind. And then this, the evidence gained from their testimony is often crucial for establishing the degree of responsibility of the accused. Well, that is one of the things that really this panel is here to answer. Is it crucial? And if so, is it fair or is it just? However, it also has another definition, which is that of a perpetrator witness. A number of those accused by the jury pleaded guilty to all or some of the crimes which they were charged and agreed to testify for the prosecution and help the court to establish the truth. And then goes on to say what the witnesses can do. And again, it is that aspect, help the court to establish the truth, that may certainly, in the minds of not just defence counsel, but all counsel, and I have no doubt the judges at the ICTY, judging by interventions that took place, as to whether they were there to help the court to establish the truth, or for reasons which were quite different, which I will come on to. So how does one sorry, just going to get the next slide. How does one identify insiders? I think, first of all, I ought to say something about the importance of insiders, because clearly on any showing, they are important witnesses. Whether they are different in kind from perpetrators is perhaps open to doubt. The insiders that we interviewed for the prosecution at ICTY were all interviewed under caution, because all of them, without an exception, in my view, certainly from the 3 cases that I did there, could be classed as suspects. Suspects, if nothing more than in the joint criminal enterprise, which was pleaded in all cases. And so they had to be interviewed under caution. Interestingly enough, and as purely as an aside, as it were, when we began this, and we really began this with the Burgeoning case, I think it was the first case where we set out to actually interview people who we regarded as insiders. And we issued prosecutors' summonses, which really had no effect under the legal system in Bosnia. You had to go to a judge to get the order, and indeed at a later stage we did. But at that early stage, and I'm going back here to the early 2000s, we simply issued a summons signed by the prosecutor to appear in Banja Luka to be interviewed. And every single one of them turned up to be interviewed, which I think was an interesting comment on the fact that official documents in the former Yugoslavia carried a great deal more weight than they might otherwise have done. Whether they establish the truth, as I've said, is another matter. One of the more famous perpetrators who pleaded guilty was Biljana Plavsic, a member of the Republika Srpska presidency, who, having pleaded guilty and made a statement saying that she was guilty, promptly wrote a book while she was in prison in Sweden, recanting everything that she has said. And of course, the impetus behind giving evidence, and when she gave evidence, she didn't actually give evidence at all because she said she was too ill and she couldn't remember it, is that a lighter sentence is expected. But what's the importance of these insiders? Well, from the prosecution point of view, it's really the only way to show the judges, however imperfectly, what was happening through there may have been records of meetings, but that didn't go behind it. What do those records actually reflect? From the defense point of view, and they are just as important to the defense as they were to the prosecution, they were hoping that the accused would be, as it were, rode out as any kind of leader or architect or putting into practice any kind of joint criminal enterprise. And third, and perhaps really last, they went some way to establishing the historical record of what happened, whether entirely accurately or not, and whether or not that was a laudable aim of these trials, about which there's a great deal of academic discussion, these insiders did assist in that. So identifying the insiders, and this is really a very quick lesson, and I apologize to all of you who are no doubt experienced. I can't, I'm afraid, stop teaching, so I'm throwing in a bit of teaching. Obviously, from names mentioned in witness statements by those who were the victims or witnesses to these events, but couldn't say, and that's the importance as well, as to what had really gone on. The documents in the trials that I did, which related to Northwest Bosnia for the main, although Micio Stanisic was, of course, the head of the police for the whole of Republika Srpska. The documents all came from raids conducted by ICTY, or nearly all from raids, on the archives in Banja Luka relating to the municipal building, the Army Corps, and the police. And those in themselves, once translated, also provided a guide to who the insiders were. From the defense point of view, there is no doubt the accused's instructions to be taken by all experienced defense counsel, and in my own domestic jurisdiction, I defended as much as I prosecuted, to be taken with a pinch of salt. And finally, of course, open source material, newspaper reports and the like. At the ICC, open source material is becoming, it can be seen, ever more important. And the admissibility of that is clearly going to be the subject of considerable legal argument in years to come. Preparation for insiders. In-depth research is absolutely vital, because when you go to interview them, you have got to know not just what they said or whether they were present, but whether there is other material which can in some way assist, or more importantly, undermine. This is doubly important when it comes to the question of deciding on an expert on an aspect of the case, where the expert himself may be someone who is in some way connected with the witnesses that you're going to be calling, or the events that you're going to be dealing with. And indeed, it's also as well to check whether or not the report that the expert produced is his own report. We had a classic one in the case of Starkic, where the expert called by the defense, who on the face of it was unconnected with the events, not only turned out to be connected with the events, but had actually entirely plagiarized his report from that of another expert. The interview has to be recorded, that's obvious, so that if necessary, you can go back to it and remind the witness of what he said, and also if he departs from it. Pre-preparing the questions, and always having two people present, because you never know if you're not going to have to call somebody. It's usually as well to have an investigator as well as a lawyer to give evidence about what happened in the interview, if there are allegations going to be made about the tape recording being turned off, or threats being made outside, or the like. And of course, most importantly, you need to check before you call the witness that he is still going to say what is in the interview. So if you've done all that, what can go wrong? Well, here are a few examples of what can go wrong when the evidence is given. As you will see, I don't mind putting myself up for, if not ridicule, I hope, for making a serious error. I called a witness who was what they call here, this report from Sense, the chairman of the municipal crisis staff, the president of the municipal crisis staff in Kota Varosh, where one of the major killings that we were dealing with took place, the massacre of 200 men in a school, a place called Grabovica. And we had interviewed him, and there was a great deal of documentation. The most important document throughout the trials was that the instructions for the organization and activities of the organs of the Serb people in Bosnia and Herzegovina, which we said, the prosecutors, was a blueprint for the takeover by the Serbs of various Muslim municipalities in Bosnia. He, not surprisingly, said that everybody did, which in fact was true. The Muslims also established crisis stars. However, the unwilling witness denied the prosecution's argument that the Serbs in Kota Varosh started preparing for war in early '92. They were going to protect themselves. When Prosecutor Corner concluded, I didn't actually conclude anything, I was suggesting, because I found myself in the position of undoubtedly having to cross-examine my own witness, which in a common law jurisdiction you couldn't do without, of course, applying to treat your witness as hostile because you've called him. The civil law judges see no difficulty because, and indeed the idea being to get at the truth, on you can go and do this. But I was suggesting that the preparations for self-defense, as he put it, was preparations for an armed conflict. As you can see, he didn't agree. And you will see a picture I put above all of these pictures, capable of telling the truth, because that's the overall test. No prosecutor should call a witness who they know is out and out lying and cannot be and has no credibility at all. There has to be a basis, at least, that he is capable and in some respects is capable of telling the truth. One of the really high up witnesses we called in the Stanisic and Juklin case was Momcilo Mandic. And I've picked this one because it shows one of the advantages that is given to the defense. He had been interviewed by us and by many others. He, as I say, you will see that he was part of the, he was the Minister of the Interior in the First Republika Srpska. In March 2010, he spent a week in The Hague for proofing with the prosecution and the defense teams. And that, of course, is a major advantage, that there is no property in a witness and each side has the ability to interview them. And you can see exactly what happened. Mandic decided to change parts of his evidence after talking to defense lawyers. And this all came out in evidence. As you can see, Mr. Mandic gave the matters some thought and remembered that he was not ordered by Micho Stanisic and so on and so forth. And he amended, further went on to say Stanisic wasn't there. It wasn't him who'd given the orders. he amended his statement that it could be remanded in custody for 30 days. I must say this was one I did like the best, claiming it was a linguistic error. So that was Mr. Mandich. Actually, I've got a photograph of him. He's a witness I will never, ever forget. Then I'm going to deal with something that came out of the Krajisnik case because of, as I say, the judges are fully aware of the nature of the evidence they're hearing. And here you can see, as I say, this was in the Krajisnik case, Predrag Radic was giving evidence, who was the mayor of Banja Luka. And Judge Ori, somewhat cynically, but possibly rightly, said that he was going to the right for 15 minutes and then 15 minutes to the left. He'd given evidence in our case. He'd been called on behalf of the defendant Bergenin, effectively to say that Bergenin had no power. However, when he was called in Krajisnik, which the prosecution team there wanted him to say, as he had said in Bergenin, that all the power lay with the ministers in Parle. Well, obviously Krajisnik didn't want him to say that. And so, as you see, he spent his time interpreting his previous statements. And when the prosecutor wanted Raj to confirm his previous statements by shifting blame for the events, he wouldn't do that. And there we see Mr. Radic. I've also taken one quote directly from the transcript of the Karadzic trial, because that was fascinating. Karadzic called on his behalf just about every single high-ranking, convicted person at ICTY, ranging from General Galich through to Starkic, Bergenin, who hadn't testified in his own trial, nor had Starkic. And he also called General Tolomir, who was the head of intelligence for many years and had also been present at Srebrenica. General Tolomir was actually on trial himself at the same time as Karadzic. And Karadzic, although he was in theory defending himself, in fact had a very highly experienced team of defense lawyers working with him, including one of the most experienced, Peter Robinson. But he called General Tolomir, and General Tolomir was there to say one thing and one thing alone, effectively, which was that Karadzic had not been told about the Srebrenica killings. And you'll see the question related to a document showing that reports were transmitted. The reports cannot be located now. Did any of them contain any information about the execution of prisoners from Srebrenica? Not surprisingly, in hindsight, thank you, Mr. President. First of all, I don't know what those reports contained because those reports were drafted by the security organ, which was at the command post at that time, and I was in jeopardy. Thus, I don't know, and so on and so forth. So it was possibly one of the more disastrous witnesses that he could have called. And there you can see the two protagonists. So finally, because I know that I hope I haven't taken up, I think I probably have taken more time, and I apologize. This panel is headed, "How can faulty evidence fail justice?" Is it faulty evidence? Almost certainly, of course it is, because of the nature of the people giving it. Does it fail justice? I would give an answer which is a qualified no. Qualified, of course, because much of it is self-serving, much of it is therefore unreliable. But in the end, in my view, insider evidence does help to give some picture, however imperfect, of how these crimes came about and what actually was being done and said by the people who were in a position to give orders. I know that Wayne is not going to agree with me because I know what he's going to be talking about, but that, I'm afraid, is not surprisingly perhaps my view. So thank you all very much for listening. I'm sorry that I've taken a little more time than I intended.
All right, thank you very much for that, Judge Corner. Yeah, I think that, very interesting observations, and I think I probably tend to agree with you. It might not be a perfect reflection of the truth, if there is such a thing, but this evidence does help us, I think, on both sides understand what has actually gone on in the conflict that we ourselves have not participated in. And obviously we'll have competing views on where the emphasis should be, whether depending on which side of the courtroom and who we are representing. But it's a fact I think for all of us that witnesses don't always say in court what they have said in their testimony. So it's very much an issue for everybody in the room. So Wayne, I will hand over to you now. And did you want me to operate your slides for you?
Yes, please. That would be great. Thank you, Annie.
Yeah, great. I'll just get them up.
Great. While that's happening, can I say thank you to the ADC for the invitation to speak about how faulty evidence can fail justice. Blessed is the man that walketh not in the counsel of the ungodly, nor standeth in the sinners, nor sitteth in the seat of the scornful. But his delight is in the law of the Lord, and in his law doth he meditate day and night. And he shall be like a tree planted by the rivers of water, that bringeth his fruit in due season. His leaf also shall not wither, and whatever he doeth shall prosper. The ungodly are not so, but are like the chaff which the wind driveth away. For the Lord knoweth the way of the righteous, but the way of the ungodly shall perish. No, ladies and gentlemen, I've not suddenly got a dose of religion. These are not my thoughts or words. These are the words of two of the appeal judges at the SCSL, Jalaga King and John Kambanda, when dismissing the RUF appeal at the SCSL. Why, might you ask, the lapse into religious fervor? How does it happen that an international criminal court would accept or tolerate appellate judges upholding a sentence of 52 years imprisonment for my client, Issa Sese, while damning the appellants as ungodly and foretelling their eternal damnation? The answer to that question is the subject of my presentation, how faulty evidence fails justice. Faulty evidence in the hands of the wrong judges can fail justice not only for the accused, that's not the point of my presentation, but for the victims, survivors, and the affected community. Convictions in the absence of reliable evidence become nothing more than an exercise in confirmation bias, or at its worst, ideological or religious vengeance. The seeds of this decline were sown at the outset of the Special Court for Sierra Leone. Mr. Crane, the prosecutor, relied upon his Sierra Leonean specialist, Corinne Dufka, to attempt to educate the OTP's investigators on the basic history of the conflict and Sierra Leonean society and culture. As she noted, with a great deal of frustration, many of the investigators from Switzerland and Canada were just not interested in the briefing materials and face no consequences from the leadership for not paying attention. In her words, as you'll see from slide 2, some of them just didn't even really know the basics. They came in having done very little reading about the history of the armed conflict or about the country. I gave them orientation packets, which they didn't read, and they would go out and do investigations, and they were ill-equipped to be doing proper criminal investigations because they hadn't done their homework. Unsurprisingly, as noted by a senior trial attorney at the Office of the Prosecutor, Kevin Taverner, many basic investigative practices common to every jurisdiction in the world were just not followed. He found that investigators working during the pre-indictment phase had almost uniformly produced witness statements with little or no corroboration, no cross-referencing between witness statements and police notes or diaries, no photographs of the scenes, no accurate records of interviews, no cross-referencing of investigations with maps, and extremely scarce forensic evidence. As you can see from slide 3, Kevin Taverner noted, quote, all we got from the investigation was a collection of statements, some of which were useful, most of which had to be redone. Really, all we ended up with were names of people and the potential statement. As lead lawyer for Issa Sese, I can confirm that's exactly what we received in our disclosure from the prosecution at the outset of the case. So the SCSL prosecution and judges were faced with a dilemma: begin again, leading to the kind of delays that had become commonplace at the ICTR and ICTY, or press on and find ways to circumvent the lack of reliable evidence. Sadly, for the accused and for justice as a whole, the prosecution and the judiciary at the SCSL chose the latter. How did they do that? First, by removing the accused's right to be informed of the charges. As you will appreciate, an accused cannot fight a case if he doesn't know what it is. Indictments must be specific enough to prevent the prosecution from introducing new material facts, i.e. new allegations amounting to separate charges or to new facts in respect of an existing charge without requiring an amendment to the indictment. That's why prosecutors must disclose a specific indictment, a specific pretrial brief, a list of witnesses, a summary of their expected evidence, a list of exhibits to be relied upon, and of course, the witness statements. And it ought to go without saying that this must take place before the trial begins. But if all you can name, if all you have is a name and a potential statement, how can you fulfill these obligations? You can't, of course. In order to compensate, the Special Court for Sierra Leone Trial Chamber 1 concluded that the indictment, the pretrial brief, or the disclosed statements did not have to contain all the charges or the material facts in the IUF case. Purporting to rely upon ICTR jurisprudence, the trial chamber concluded, and you'll see this in slide, quote, the sheer scale of the alleged crimes made it impracticable to require a high degree of specificity in such matters as the identity of the victims and the time and place of the events. This was an intentional misreading of the jurisprudence that articulates a narrow exception to the pleading requirements that allows some information, such as the identity of the victims and the dates, to be missed out. And of course, that makes sense. An accused does not necessarily need those details to defend the case. At the Special Court for Sierra Leone, Trial Chamber 1 distorted that narrow exception to include the place of the events. So in other words, the prosecution now were under no obligation to plead the victims, the precise date, or even where an event occurred. Attempting to excuse the inexcusable at the final judgment stage, the trial chamber noted that since the trial was intended, quote, to proceed as expeditiously as possible in an immediate post-conflict environment, close quote, the prosecution was not required to plead the totality of its case. In short, in order to ensure the trial could start expeditiously, the accused was not entitled to know in advance the basics, not even where a crime had occurred. Very helpful for the prosecution, of course. It gave them carte blanche to gather new evidence throughout the course of the trial and lead it through statements. But what of the requirement that evidence should be disclosed at the commencement of the case, except in exceptional cases, and that new charges require an amendment of the indictment? So Trial Chamber 1 invented a new admissibility test that would have embarrassed even Kafka if he'd been sitting on the bench. Evidence or allegations were no longer new if, as you can see from slide 5, they, quote, relate to separate and constituent different episodic events, or are, as it were, building blocks constituting an integral part of and connected with the same res gestae, forming the factual substratum of the charges in the indictment. Quite a mouthful. Of course, makes no sense either. Especially when you have an indictment which alleges an all-encompassing joint criminal enterprise to take over the country at all costs, including by the commission of war crimes and crimes against humanity. So anything new that was alleged, that was relevant to the original charges in the indictment, and was testified to by any witness at any time during the trial, was thus no longer new, as long as it was relevant to the RUF's attempt to take over the country by force. And of course, not being new meant no remedies were required. No time to investigate the new material, no recall of witnesses to question them about the new allegations, no exclusion of evidence, nothing. But Your Honours, it's never been mentioned in the indictment, pretrial brief, or disclosure of evidence. Move on, Mr. Jordache, it's not new. It's a building block of the res gestae of the charges. Nothing was new, even the new. Unsurprisingly, this innovation led to over 250 new charges and 150 de facto amendments to the charges, hundreds of new material facts, and thousands of new facts, cascading through the courtroom, witness by witness, throughout the 4 years of trial. Of course, such a drip of evidence cannot produce reliable evidence. And of course, one still needs the cooperation of insider witnesses, who, as we heard from Justice Corner, come to the court with, let's say, a great deal of baggage. Now, I'm not of the view that insider witnesses are not valuable. They're very valuable, but of course they need to be treated with care. How do you obtain the cooperation of insider witnesses when the trial has already begun in earnest and you're looking everywhere for evidence? And so the prosecution decided to pay their most important witnesses for the trouble. Witnesses admitted on oath that the prosecution had given them payments as gifts. In one instance, a critical prosecution witness admitted that the prosecutor gave him an unknown quantity of money in an envelope and said, quote, please put it into good use and take care of yourself. Another potential witness was taken on fully funded Sunday lunch excursions to one of the most expensive and exclusive seaside resorts. A critical accomplice witness against my client confessed that his life had been demonstrably improved as a result of the payments. He was now able to, quote, sleep in a decent place, had decent food to eat, and could now change his clothes. He candidly admitted on oath that he was now motivated to help the prosecution. Yes, I want to help them today and tomorrow. I want to help them. Were they telling the truth? Well, yes, sadly they were. Many, but not by any means, all of the payments were recorded. Some of the biggest criminals in the world, and that's the baggage that insider witnesses come with, became rich, paid for information, time wasted, schooling, to support parents, meals in expensive restaurants, etc., etc., etc. Thousands of dollars in one of the poorest countries in the world to some of the most damaged witnesses in the world. To watch Trial Chamber 1 wriggle out of addressing this unconscionable conduct made for uncomfortable viewing, at least for anyone who cares about justice. During the trial chamber claimed to be confused when we, the defense, raised the issue. They sought to reframe the complaints as somehow casting imputations upon them and therefore impermissible. The court objected to the suggestion that witnesses were being bribed, claiming that the accusation amounted to a veiled suggestion, quote, that the justice process is being called into question. Claiming to be utterly confused by the simple and recurring question of bribery, Justice Boutte queried, quote, "I don't know where you want us to place ourselves with this evidence," close quote. Well, indeed, Your Honour, where should judges place themselves when faced with that kind of evidence of the exchange of thousands of dollars for belated testimony dripped into the courtroom over a 4-year period? So difficult to work out. So all the new allegations and all the new evidence was admitted, unsurprisingly, replete with lies and inconsistencies. Faulty was barely the word. It couldn't withstand the burden and standard of proof. So what did the trial chamber do then? Well, they created several express presumptions of guilt that obviated the need to consider the evidence at all. The two most damning were as follows. First, the chamber concluded that the mere fact that the IUF accused intended armed rebellions meant that they also intended the crimes. As the judgment observed at paragraph 2016, if you look at slide 6 now, it indeed goes without saying, and the chamber so concludes, that resorting to arms to secure a total redemption and using them to topple a government which the IUF characterized as corrupt necessarily implies the resolve and determination to shed blood and commit the crimes for which the accused are indicted. As is plain from this remarkable statement, the chamber went further than assessing the evidence with a presumption of guilt. In the minds of Trial Chamber 1, rebellion against the government necessarily implied an intention to commit war crimes and crimes against humanity. Picking up an AK-47 was now tantamount to an intent to commit these crimes. The second presumption, and there are many, and I've only got time to deal with 2, but the second and my personal favorite, you can see at slide 7, a presumption that any evidence that cast doubt on the existence of crimes was not worthy of any weight. As the trial chamber said in the judgment, it does not follow that a crime that did not occur, it does not follow that a crime did not occur merely because an individual says he did not hear of it or of the event. The chamber attaches no weight whatsoever to this and similar evidence in making determinations about whether crimes have been committed or not. In other words, a blanket acceptance of all crimes and a blanket rejection of any witness evidence which said it didn't happen. In the final judgments, justice continued along the same tortured and unfair path, avoiding any examination of the evidence because such an examination would have found it severely wanting. Mr. Sese received 52 years for his resort to arms to topple a government. Despite adducing evidence for 4 years showing that the prosecution were bribing their witnesses, not a single mention in the judgment, nothing. Despite submitting lengthy annexes showing totaling hundreds of pages showing witness inconsistency, not a mention. The only mention of evidence was direct evidence from prosecution statements, nothing concerning cross-examination. Despite 7 months of a defense case for Mr. Sese, over 100 defense witnesses, including the head of the UN peacekeepers, 3 West African presidents, and a myriad of independent civilians to explain or mitigate the case against him, their evidence dismissed in 15 paragraphs of a 500-page judgment. Let me say that again, 15 paragraphs of a 500-page judgment. The appeals chamber was no more interested in examining the evidence or ensuring justice than the prosecution trial chamber was. As for the presumption of guilt that any action in furtherance of rebellion was the same as an intention to commit war crimes and crimes against humanity, the appeals chamber didn't even bother to comment on it, not a reference to it. As for the 250 additional charges and 150 amendments to the charges admitted after the case commenced, dismissed on a technicality. The appeals chamber would not consider the prejudice arising because the voluminous annexes required to list the additional charges and evidence was alleged to be in violation of the page limit for the appeal. Ditto with regard to the annexes showing the inconsistencies that had been ignored by the trial chamber. Too many of them, so in violation of the page limit for the appeal. As for paying of the witnesses, despite the fact that there's not a single mention of them in the judgment, in the trial judgment, the appeals chamber simply claimed that there had been a thorough consideration of the issue. When preparing for this presentation, I went to the website of the Residual Special Court for Sierra Leone, and it says, quote, "For international justice, the Special Court's legacy will be its jurisprudence. For international tribunals, it may be its innovative outreach program or its unique experience in being the first hybrid ad hoc court, as well as the first court since Nuremberg to achieve its mandate and to close." This is the bit I want to focus on as I come to an end. Quote, "For the people of Sierra Leone, the court's legacy will be weighed as to its contribution to justice and reconciliation, the re-establishing of the rule of law following a decade of conflict, and the fight against impunity for serious crimes." Really. What I find fascinating personally about what happened at the SCSL is the journey from a court requiring evidence to one requiring none, and the judicial and prosecutorial collusion that was required to go down that path. Not one prosecutor or judge commented on this corruption of a whole judicial process, leading to unjust convictions and lengthy sentences. It's an anthropological lesson in collective blindness akin to the famous Milgram experiment. But for today, that is not my focus. The SCSL is right. The court's legacy will be weighed as to its contribution to justice, the re-establishment of the rule of law, and the fight against impunity for serious crimes. But what can you learn from the IUF trial? That evidence doesn't matter. That power and authority, whether at the end of a gun or wielded by an international court, is in the end the same as truth. That ideology or Old Testament damnation trumps justice, that the rule of law is malleable. I'm not quite sure these are quite the lessons that the SCSL came to deliver for the people of Sierra Leone, but sadly, that is what occurred. Thank you very much for listening.
Thank you, Wayne. Well, that was fairly dismaying. But thank you very much for bringing that to us all in such detail. Yeah, and I mean, we're not, some trials are better than others, and that is not to say that what has happened in this trial is not incredibly serious in and of itself. And I think that will give everybody a lot of food for thought. All right, moving on to the next speaker. Felicity, if you're ready to take the floor.
Hello, can you hear me? And can you see my slide that's headed panel 2, how can faulty evidence fail justice? Thank you. Well, first of all, I'd like to thank the ADC for inviting me to speak at this session. Secondly, I'm not going to say thank you to Wayne because it's an enormously difficult presentation to follow and a very moving presentation to follow and a fascinating insight into what happened in that trial. So Wayne, thank you, I suppose, for giving me the hardest task to follow. And most of you will know me from my amicus curiae brief in the Radovan Karadzic appeal that related to the case of Jogi. Today, I've been asked to speak about the contents of a chapter in the book, Annotated Leading Cases of International Criminal Tribunals, particularly relating to the extraordinary chambers of the courts of Cambodia that was published this year. As a contributor to the research handbook on feminist engagement in international law, I'm delighted to see lots of women and to be a woman presenting at an event like this. I speak a lot about the visibility of women. And some of you may know me from the Charlotte Seamstress moot in the ICC Moot Court manual back in 2012. So I've been knocking around on the fringes of international law for quite a long time. And those of you who do know me know that I like to think about what on earth do things mean? So when I was given this title, which I think again Wayne had something to do with, what strikes me is, what do we mean by faulty? And whilst a chapter in a book is a commentary trying to present what we can find from cases decided in international courts, when one's trying to present at a conference like this, one starts to unpack what you're being asked to do. And does faulty mean unreliable, irrelevant, or untested? What other words can we ascribe to faulty? I'll perhaps leave those for you to think about as I tell you what these cases decided. And then what do we mean by justice, which has been a question that we've asked ourselves for centuries, if not millennia. I quite like the Aristotle quote that justice is somewhere between the two extremes of unfairness. And I think what we've just heard perhaps supports my liking of that quote. Can we find the mathematical mean between those two extremes of unfairness? Is there an equilibrium? It's something I've asked myself for many, many years. When we think about justice being done and justice being seen to be done, the most we can do as practitioners is to examine cases. And me being a bit of a hybrid practitioner academic is to try and examine those cases as to what does it all mean. So if you can keep those thoughts in mind, those big thoughts in mind, I'm actually going to give you a canter through the practical outcomes in these cases. So what I was asked to do for the book chapter was examine 5 decisions, and I've listed them there. Obviously, I'm not going to read to you. I think the one thing I want to say here is they're almost impenetrable. It took a long time just to read them. I think one of the problems with justice is international judges probably need to write a little more clearly. And I've certainly had more than one occasion to speak to a judge about having 2 decisions, one being the decision of the court with all the jurisprudence and another one that's accessible. And I think there are some moves to that now, but these decisions are not at all accessible. So it's quite hard work. So in promoting my chapter in the book, I'm now telling you how hard it is to sometimes penetrate the reasoning of the courts in making these decisions about evidence that allows us to think about whether that evidence is faulty or not. And what I said in the commentary is, taken together, the analysis suggests an attempt at least to formulate a consistent approach to procedural fairness. So what the courts decided at the different levels, so we had an ongoing investigation, trial judges making decisions, investigating judges making decisions, and an appellate court. And essentially, I think what you can fathom from all those decisions is that the disclosure exercise must be directed to the issues under consideration, and the assessment of material can be conducted confidentially. Secondly, where evidence is obtained through torture, it won't be admitted for either the prosecution or the defence. There is an unless to that I'll come to later, although derivative evidence and evidence obtained by coercion or ill treatment may be included. Thirdly, where case management orders are not complied with, material will be excluded. And we've heard an example of that from Wayne. The result is that apparently relevant evidence should be disclosed, but might not be admissible, and the court retains control over procedural fairness. So what might start out as faulty evidence can become the fault of the court, which I think is a really interesting concept. It remains a practical issue that the ECCC rules differentiate between a suspect and a charged person. That gives limited rights to a suspect during the investigation period. And the result being that if someone is charged, the defence are then given access to a case file which is already voluminous, and making challenges to non-disclosure is a significant task. So the first topic these cases dealt with was disclosure, and disclosure generally. These are quite wordy slides, but I'll try and summarise them as I go along. Essentially, the core of the appeal was that other senior figures that acted independently in committing crimes attributed to the appellant. And the appellant's position was that the fresh evidence from those investigations would serve to exonerate him. So what you might think is a fairly straightforward task. But the prosecution then opposed any further disclosure, relying on an existing examination that they'd carried out for cases 3 and 4 and suggesting that the appeal was speculative. So what you had here on an appeal was a prosecution saying that we've already done this exercise in the other 2 cases. Why should we bother to do it in this case? He's just trying it on. So your vision of justice there is a prosecution team, firstly indicating they're not prepared to carry out the exercise at all in relation to the appeal, and secondly inviting a form of summary justice on appellate jurisdiction. Fortunately, that wasn't the outcome. So what an analysis of these cases showed that both disclosure generally and emerging confidential disclosure arrangements envisaged a potential outcome where an indictment could be stayed or a conviction could be quashed if non-disclosure creates unfairness. Such mechanisms place the burden on prosecutors, in my opinion anyway, to ensure that disclosure is not merely dismissed as too costly and time-consuming, which was really the argument that was being raised in that appeal. And what the Supreme Court chamber acknowledged was the tension between an individual right to a fair trial and the importance of preserving the integrity of ongoing investigations in other cases. So that's a tension that we can all understand, but it doesn't take away those rights of individuals in these complex cases. And the quote here, I think, is quite interesting. So the Supreme Court chamber recognised the co-investigating judge's duty to guarantee the confidentiality of the investigation. Nevertheless, it must also fulfil its own duty to assess whether a fair trial may still be conducted despite restrictions on the disclosure of evidence. So I think this idea that you can actually stop everything is just really important. It is what's meant to direct disclosure. Do it properly or we'll stop everything. Whether you can persuade a court to stop everything, I think what we've just heard from Wayne is probably pie in the sky, but it's there. And there is a core to these cases that says, you know, in more than one jurisdiction, we've had a think now, you don't do it properly, you don't do it at all, which I think is really interesting. So there was this call to review, and they did have to go away and review all the material. So they reiterated the co-prosecutors, the chamber reiterated the co-prosecutors' continuing obligation to disclose, and they formulated a test for disclosure. And you can see it there, that may suggest the innocence or mitigate the guilt of the accused or affect the reliability of the evidence. So I think that's really interesting, suggesting innocence, mitigating guilt, which isn't necessarily a trial issue normally, and or affecting the reliability of evidence. So the premise of the grant was that any evidence examined by the prosecution must be considered in relation to the issues raised in that particular case. And it was held to be sufficient for the defence to show there's prima facie that the material may have an exonerating or mitigating value. Of course, that means it dumps a whole lot more material on the desk of the defence, but it gives the defence the opportunity to decide whether it's faulty in those terms that I've suggested: unreliable, irrelevant, untested, or even useful. I think this issue of reliability really interesting when you're dealing with the jurisdiction that is trying to tread the line between common law and civil law procedural conduct, and thinking about this search for truth. Then reliability really does become an issue during the course of the trial that the defence really need to be engaged in. You need to be engaged in just as much as the prosecution. So these are really interesting decisions, because there was a real consideration of the interface between the fair trial, the rights of co-investigating judges to protect investigations. But the real point of the disclosure exercise, it seems to me, that these cases were trying to say was that you must direct it to the issues under particular consideration. Of course, that in a sense requires the defence to identify those issues. But when you're considering the scope of what you need to consider, either in trial, in investigations, or on appeal, this isn't about initial inspections. It isn't about initial issues. It's about looking at the core issues. And when you think about it, what the core issue here was, look, these people were acting independently. It was not me. So there is at least an argument that pretty much everything would be relevant as to what everybody else was doing at that particular time. And it could be over a number of years. And there was then a consideration of by the investigating judges and the sort of test that could be applied there. So these cases are sort of deciding both both separately and together to try and formulate a test for disclosure. This language of not limited to mitigating guilt or reliability is suggested in the appeal. But what the investigation judges said, well, hang on a minute, we've got to consider whether it's relevant. Now, I think that's interesting in itself because it's that objective view of what relevance is. And we all know in criminal trials that actually it can be a piece of evidence that sometimes feels peripheral, but during the course of the trial becomes the core piece of evidence that makes a difference to the decision maker. So the investigating judge here said, well, disclosure must not jeopardize the confidentiality and integrity of the judicial investigations that you've got going on at the same time in the other cases as the appeal. The primary obligation, restrictions and modalities might be attached to disclosure in those circumstances. The investigating judge maintains the sole prerogative to revoke disclosure authorizations, but then the requested material must be prima facie relevant to the proceedings to which they're disclosed. And fortunately or unfortunately, whichever your perspective, that was expressed as a low standard necessary so as not to prejudice the requesting parties. So you've got this sort of high level thinking about confidentiality and then this apparently low level test. And I think it'd be interesting to watch that work itself out as to whether it really is a low level test. But what you come away with from reading those cases, and obviously I suggest reading the book chapter, the cases are difficult to read, but is that it's meant to be about fairness issues and not resources. So there is this duty of continuing disclosure. It's intrinsic to the fairness of proceedings. If you say it's too hard, that's not sufficient. You have to examine the material having regard to the issues that relate to a particular appellant and the matters in the particular proceedings. And the suggestion of innocence or mitigation of guilt is determined by relevance to the issues under consideration in the particular case concerned. But I think that question of mitigating guilt is really interesting, that you're pulling in questions that we might normally think around sentencing into the disclosure exercise. So as a level of criminal responsibility. And I think that's really important in certainly international courts, when you have people on trial, for example, as an alleged joint criminal enterprise, when you're trying to think about levels of criminal responsibility, what you're really thinking about is levels of involvement at all. So I think that language of mitigation of guilt is really interesting. Now, I don't want to crack on for too long and use up too much of my time, but we can see here that the ECCC did adopt this similar approach as Lubanga to say, well, look, if you don't do it properly, then there is precedent here to have a stay. So taken together, what we are able to do is take an overview of the commentary, that there are these practical difficulties, but the idea is that it is meant to be fair. And the quote here, unless at the time of the release of this decision, the disclosure of the two documents identified as falling within the categories of potentially exculpatory evidence described in the request has taken place, the co-prosecutors are instructed to seek leave to disclose on a confidential basis documents. So here we're moving on to confidential information. So what they've said is, well, you've got to have a mechanism where you can give the defense or the appellant confidential information as well. But if you really can't find a way to do that, then the court is going to have a confidential process. And it's not clear from these decisions necessarily how that confidential process would work. It looks to be a little bit similar to the ways in the cases in England and Wales have worked. But at the moment, there's no discussion over how that would work, how it reduces the level of transparency, how this works in context of public interest, and whether or not there ought to be a system of special counsel. So I think there's quite a lot of work to do there on confidentiality. And it does seem to be given primacy in the way in which, certainly in the investigating judges' decisions are expressed. In terms of evidence obtained by torture, these decisions say a lot of what I think is going to be dealt with by the next speaker, so I won't go into it in too much detail. I've tried to do it in a simple way. The Supreme Court Chamber excuse me, I've got a stinking cold today, concluded that in the light of the objects and purposes of CAT and the cases discussed, they were going to give full effect to the exclusionary rule. So any evidence obtained by torture was not going to be admitted. This might include derivative evidence. So the free admissibility of evidence militates in favour of accepting derivative evidence so long as proposed use does not circumvent the prohibition against invoking the contents of torture tainted confessions to establish truth. However, the prohibitive value of such evidence will be assessed on a case-by-case basis. It's that way of saying we're not having any evidence obtained by torture, and that's probably going to include derivative evidence, but it will make it sound like it doesn't by saying it's going to be decided on a case-by-case basis. So this is a really forceful decision on the non-admissibility of evidence obtained by torture, and it includes defence evidence. They said that contrary to the defence submission, the Chamber considers that the CAT is not limited in application to state authorities. Now, there is an unless, which I've not put on the slides, that reads, I've got it here for you, in my way of encouraging you to read the book. They said, given this, they stated that save for the potential rare exception where there was extreme necessity based on combined factors of the provenance of evidence, its reliability, its overwhelming exonerating value and its uniqueness, and where preventing its use would amount to a flagrant denial of justice. And frankly, I don't know what a flagrant denial of justice means. It's a denial of justice, whether it's flagrant or otherwise. So what's quite interesting here is that the unless provision, if you like, in relation to defence evidence, it is a very, very high bar. So you're looking here at trying to balance the interest in not admitting evidence of, obtained by torture, which of course there is real interest in and really important to engage in that jurisprudence. But at the same time, what is the test to ensure that someone receives a fair trial? These questions of justice are really going to test us. I think I'm going to be told to hurry up and shut up now.
Yes, so exactly.
Yeah, all right.
Apologies.
No, not at all.
You can have a minute or two to wrap it up by all means.
Absolutely. So the next section is case management, as Wayne's already told us: page limitations, late documents, administrative error, piecemeal evidence, further evidence, imminent evidence, and further witness evidence. The answer is no, you don't comply with the rules, however unfair that might be. I would have stopped there, but I was asked to say something about JCE, in addition to what I was asked to say about the ECCC. I fitted it onto one slide, which is my message from Jogi is this: the infection of international courts by the mistake in Jogi is a fundamental error that we do have to consider. What happened was we abolished in England and Wales felony murder, which was an objective test for foresight of probable consequences. The courts then made up a test for subjective foresight of possibilities and said that it was illogical. If you look at Powell and English, they said it's illogical, but we're going to keep it to deal with these people. If you look at Chan Kam-shing in Hong Kong that I was in, they said, well, we're going to keep it to deal with these people. It doesn't have an eye on knowledge or intention or foresight as a question of remoteness, which is what it really is. I've given you the link there to an article I wrote in Council magazine on remoteness. It allows for wide inferences that bear no relevance whatsoever to real criminal responsibility. And at the moment, the language of cases in England and Wales is also infecting the international courts by the use of the word nexus, which frankly means nothing. So my little message at the end is it's just a colonial error that we ought to expunge from all courts for reasons I can tell you in some other lecture. I'm sorry for not cantering fast enough, should have galloped. Thank you very much. That's the end. That's and great. I'll stop sharing.
Thank you, Felicity. There's so much that I would love to talk to you about, so I'll grab you at the break maybe. But just so that we don't waste any further time, I will pass off to Melinda now.
Thank you very much, Annie, and thank you very much to the ADC for inviting me to speak on this panel. And I've enjoyed the excellent presentations from Judge Corner, from Wayne, and Felicity. I'm going to be dealing with a very specific type of scenario which almost piggybacks off their presentation, and that is the good cop versus bad cop scenario. But instead of being a bad 80s buddy movie, I'm going to deal with the field of mutual legal assistance, where one state or entity collects evidence from a person while they're being held in detention by a state that's known for committing abuses of human rights or even torture. And I think this is a scenario which has arisen in particular in a post 9/11 situation, where you have a suspect being held in a black site by state A, which is a situation of prolonged arbitrary detention. Entity B swoops in, interviews or collects evidence from this individual, potentially in a third location, but they're still in the clutches of state A. And it's a scenario that will continue to arise at international courts and tribunals by virtue of the fact that these types of individuals are essentially low-hanging fruit. They're easy to access, they're likely to be insiders, and they're therefore ripe for the picking. But these low-hanging fruits can also be the fruits of the poisonous tree. Now, as a defense counsel, obviously this raises issues. If you're appointed as a duty counsel to defend such a person, should you participate? Can you participate? Is it lawful to conduct such interviews? Is your client in a position to provide free and informed consent if they're being held in an inherently coercive environment? And if the prosecutor collects evidence from these individuals, in what circumstances is the exclusionary rule triggered if the international prosecutor did not themselves directly engage in mistreatment or authorize it? Now, to paint a picture of what this type of scenario might involve, I'm going to deal with a specific witness who testified recently in the Al Hassan case, and I'm relying on open session extracts. Now, this is a witness P626. He was basically detained by national authorities in a location which the United Nations has described as being illegal. It's a black site in effect. Now, at the time that he was interviewed by the ICC prosecution, he'd been detained there for 2 months. He was incommunicado and he had been held in solitary confinement. The ICC prosecution was effectively the first person or entity he had seen in 2 months. He'd been handcuffed 24/7. And in fact, one of the handcuffs was still on him during the interviews because they couldn't get it off. It was broken, the entire interview. There was a duty counsel present, and he was informed of his rights under the statute, Article 55(2), his right to be silent, although the prosecution did emphasize repeatedly that they were only interviewing him as a witness. Now, both the duty counsel and this witness complained about the conditions of detention to the prosecution. That's in the transcripts. And he later testified that he had been under great suffering to such an extent that even though they told him he was only a witness, he in effect begged them to arrest him, to take him into the jurisdiction of the ICC rather than leave him there. Now, after he made these complaints, the prosecution told him, either you want to answer our questions and you feel in a position or a state to do so, and then we will put questions to you and you answer. But if you do not wish to do so, for whatever reason, we will pack up and leave. And when he testified at the ICC, we asked him, what did he think would happen if the prosecution had packed up and left him there? And he responded, you could expect anything while in those conditions. You can expect to die of thirst. If I ran out of water and knocked on the door asking for the guards to help me out, they would only respond when they wanted to. That's how it worked. So he kept speaking to the prosecution. And after a couple of weeks, he was transferred to a different facility with better conditions. And I'm going to read out the extract from the transcripts, which charts this progression from one facility to the next. Now, Mr. Witness, is it correct that after you met the Malian prosecutor and after your transfer, there was a substantial improvement in your conditions? Answer, that is true. Question, and did you believe that the prosecution, the ICC prosecution, had played a role in bringing this about? Answer, yes, I believe so because I insisted. I repeatedly asked them to do something. They promised me that they would request it, but they would put a word in to the deputy regarding this matter. Question. Now, Mr. Witness, at the end of this exchange, it says, over the last few days, the fact that I feel so at ease, I'm thinking with regard to the information, how can I assist you? You have come from so far afield in order to gather this information. Mr. Witness, is it correct that you said this to the ICC prosecution? Answer, yes. Question, and that was because you were grateful for the assistance they provided to you? Answer, yes. So here we have a situation where the ICC prosecution has not physically mistreated the witness, far from it. They may have even saved his life, or at least the remnants of his sanity. But the witness knows this. He's very grateful, and in his own words, was thinking, how could he help the prosecution in terms of the information he gave them? Now, I'm not going to comment further on this particular case, but I am going to move on to how similar scenarios have been dealt with by national authorities. And here I'd like to give a shout out to Maria Leary and Michael Hertz for the brilliant research that they've done and provided to us in this case. And I'm also going to note that I've roped in Annie O'Reilly, the moderator, to help me with this, because I'm actually going to make these jurisdictions anonymous. And I'm going to ask Annie to guess which jurisdiction I'm talking about at the end. Obviously, the audience can as well in the comments. Now, my first lucky jurisdiction is jurisdiction A. Now, this jurisdiction, this lucky country, was involved in forays of a Middle Eastern nature, and the complaint arose as concerns the manner in which officers had collaborated with states who were known for engaging in human rights abuses. So this entity ordered a Human Rights Committee to prepare a report on potential complicity. The committee heard expert evidence on the notion of complicity to determine what threshold would engage the responsibility of that state in circumstances where the agents had not themselves engaged in mistreatment or authorized it. And they concluded that complicity means simply one state giving assistance to another state in the commission of torture, or acquiescence in such torture in the knowledge, including constructive knowledge, of the circumstances in which the torture had taken place. An inquiry was then initiated into specific incidents of detainee mistreatment. And this is their conclusion in relation to the specific scenario we've discussed today. And it was that if a detainee had made a complaint to the interviewing officer about their conditions of detention, that officer was obliged to cease any engagement with the individual. They were then obliged to investigate the claims of mistreatment before they could engage with that individual again. And it was not acceptable to simply interview the individual in a different location, for example, a porter cabin. Now, this entity then promulgated principles that regulate the procedures that would apply to detainees who are held by foreign states, and essentially requires the interviewing officer to take into account whether the person is being held in unacceptable conditions of detention. And these are the factors they set out to determine that: the lawfulness of arrest or detention under domestic law, whether they were held incommunicado, whether the detainee knew the reasons for detention, the conditions of detention, and whether the detainee was likely to receive a fair trial in that foreign jurisdiction. Now, our choices are A, Australia, B, Canada, C, United Kingdom.
Okay, I'm going to ask the audience. No, but seriously, I'd like just give it a go. Drop your answer into the comment box, if you would be so kind. I do have an answer. I've written it down.
Okay.
But I'd like to see what other people think first.
What we can do is we can come back to this at the end, so people have time to submit their answers, because I have 3 jurisdictions to go through. So my second jurisdiction, this is jurisdiction B. And in this scenario, the investigators from jurisdiction B flew to an African country, let's call it D, and they interviewed several individuals who were held by this country in a situation of incommunicado detention. Now, the detained individuals were later arrested on the basis of these statements and taken to jurisdiction B, and they claimed that they'd been subjected to various forms of physical mistreatment by the D authorities while they were detained by country D. And they claimed that the voluntary nature of their interviews had been completely vitiated by the coercive conditions of their detention. They did acknowledge that they had not complained about these abuses at the time of the interviews, but they said this was due to fear of retaliation. Now, that jurisdiction said that the legal threshold for obtaining a remedy and potential exclusion of evidence depended on whether there was a joint venture between jurisdiction B and country D. And the court in that country or jurisdiction found that the threshold was satisfied, and they excluded the statements. And these were the key findings. Firstly, although jurisdiction B interviewing authorities were aware that the detainees were being held in incommunicado, they only made cursory inquiries as concerns the conditions of detention. They did not inspect the conditions of detention, and they were not in contact with the detainees during the periods between interviews. So they didn't exercise any effective oversight over the detention to ensure that it was not coercive. Secondly, jurisdiction B relied upon country D to transport the detainees to and from the interviews. And sometimes officials from country D were present during the interviews. Thirdly, although the conditions of detention in country D had improved in the immediate lead up to the interviews, there was no corresponding change in the circumstances of detention that would actually cure the coercive nature of the detention. And in light of the above, they found that the individuals had not waived their right to silence in a knowing and intelligent manner. It was an involuntary waiver of the right to silence. Now, for this scenario, our choices are ICTR, ICC, United States, Germany. I'm now moving on to my third and final jurisdiction. Now, this is a very similar factual scenario to the last one. Jurisdiction C interviews the individual in state E, while the individual was held incommunicado. Except in this scenario, the detainee is recorded as complaining to the officer of jurisdiction C about being subjected to physical torture, verbal threats that he'd be killed unless he told the truth, and extremely poor detention conditions. He made these complaints on the first day of interview and throughout the interview process, which occurred over the course of several months. The detainee was read his rights during the interview, and he had a duty lawyer present. Now, when this person came before jurisdiction C, he argued that in accordance with human rights law, as soon as he made these arguments or complaints to the interviewing officers, they should have disengaged from the interview process, they should have investigated the claims, and they should have suspended the interviews until he had been transferred to a lawful detention facility and until his fitness to be interviewed had been assessed. He further argued as a matter of law that the court should look into and apply the principles set out in the Istanbul Protocol. Now, that's a manual that's been promulgated by the High Commissioner for Human Rights on the basis of the Torture Convention, and it sets out certain procedures that should be followed when interviewing someone in a custodial setting. And he also argued that because this particular domestic state had ratified the African Convention on Human and People's Rights, they should apply the principles of fair trial promulgated by the African Commission, which specifies that any confession extracted from a person who's held in arbitrary or incommunicado detention is inadmissible. Now, the court in this jurisdiction found that a remedy was dependent on showing concerted action or a nexus between the effects or actions produced by the torturing authority, and then the interviews conducted by the officers from jurisdiction C. Now, in terms of how they dealt with this as a matter of law, they found that definitions of individual complicity that had been adopted by international criminal courts or human rights courts were of limited relevance. They said that definitions of state or organizational responsibility were of no relevance. They found that the principles set out in the Istanbul Protocol and the African guidelines were not binding or applicable. And they ultimately found this necessary nexus element was not satisfied because in the interviews, the officers from jurisdiction C had informed the detainee that the procedures were separate, that they were separate from the national authorities, and that they had no influence over the national authorities. So they couldn't change anything, they couldn't make it better. In reaching this conclusion, the court emphasized that you had to consider the context, the practical realities in which the investigations are conducted. That is, that investigators will often be wholly dependent on the cooperation of naughty, that's my words, states. And for this reason, you can't have too strict an approach to the exclusion of evidence. Now, our choices are ICTR, United States, ICC, or South Africa. So that was my third and final jurisdiction. So shall we go back to the first jurisdiction? Annie,
Yeah.
what are the guesses?
So I see there's one person who thinks it's UK. I don't know if anybody else wants to weigh in on that. I would have also gone for UK, and I can prove it with my notes. But of course, I've no idea. I've no particular knowledge. It's been a while since I've looked at it specifically. So that would be my guess for the first year.
Absolutely right. That was definitely the United Kingdom. The first, I was referring to the Joint Committee on Human Rights from 2009, and then the Intelligence and Security Committee of the Parliament, their detainee mistreatment and rendition report. And then the final one was the principles relating to the detention and interviewing of detainees overseas, which was promulgated in 2019.
Very interesting.
Our second jurisdiction.
Okay. I'm about to embarrass myself for my ignorance, I think. I went for Germany with no real idea. It says not the correct one.
This was actually, and surprisingly, the United States.
Oh.
It was the case of United States versus Karake, and it concerned US officers who were interviewing individuals in Rwanda at Kami camp. And basically these individuals were suspected of having killed American tourists. And obviously the court rejected their statements when they were tried in the US, and they actually terminated the proceedings as a result. It's a fascinating case, highly recommend it.
What year was that case?
2006. I can send the references along later as well.
Yeah, please do. Right, for the third one, what were the choices again?
They were ICTR, United States, ICC, or South Africa.
Okay, well, it might just be my cynicism having spent 6 years there, but it did sound awfully like the ICC to me. But please reveal the answer.
You are correct. The ICC, and the decision issued this year in the Alassane case on our request to exclude what we had characterized as torture tainted evidence.
Fantastic. Well, thanks for that. Any closing remarks, or shall we move to questions now?
No, I think it just simply shows how, or squares the circle with the earlier panel today in terms of how state cooperation and the practical realities attendant to that can impact on the evidence gathering process and the particular standards that are applied by these courts. But I think it's better to open up the floor to questions.
Yeah, thank you very much for that, Melinda. I certainly had fun playing that game, even if I didn't do that well. I know that we are just over the time, so what I would suggest is taking 1 or 2 questions now, and then there will be breakout rooms open from 2, so we can continue the discussion then. But if anybody has any questions right now, we will just extend for a couple of minutes to take 1 or 2. See if anyone has there. Okay, I suspect people might just be very hungry, which is fair enough. So thank you to all the panelists for very, very interesting and informative presentations this morning. And please go find them in the breakout rooms after too, so you can ask your questions then. So breakout rooms at 2, and then we will resume, I think, at 2:30 for the third panel of the day. All right, thanks very much, everybody. And see you now.
Okay, good morning or good afternoon to everyone, whichever may be the case for you. It's now time for our third panel today, entitled An Epilogue to Proceedings, What Happens Next? Today we have a distinguished panel of 4 experts, each with a particular analysis relevant to this issue or topic. And I wish to remind everyone that the speakers will have approximately 15 to 20 minutes for their presentation, and thereafter we will open up the floor for questions from the audience. Before we begin, I would like to give a brief introduction to the members of the panel. First, we have Mr. Peter Haynes, QC, who is a British barrister specializing in international criminal and humanitarian law. Peter was educated at the Rencombe College and graduated in law from the University of Birmingham. He was called to the Bar of England and Wales by Gray's Inn in 1983 and appointed to Queen's Counsel in 2008. He is a member of St. Philip's Chambers in Birmingham. As I'm sure most of you will recall, Peter has acted as defense counsel in several matters before the ICTY, including for General Pandurovic and for Mr. Avramovich and Mr. Simic. At the ICC, Peter was the defense counsel for Mr. Bemba, and after obtaining his acquittal, Peter filed a claim on behalf of Mr. Bemba for damages in excess of 60 million euros for unlawful incarceration, aggravated damages, legal fees, and damage to property that had been seized of Mr. Bemba. Peter has also acted as lead counsel for participating victims at the STL. And in addition to serving on various governing bodies of the ADC over the years, Peter also served previously as the president of the ICC-BA. And I am told that since 2016, he has been the president of the Moseley Ashfield Cricket Club. He will be talking to us today about the issues after acquittal in the Bemba case at the ICC. We also have with us today Dorothy Lefrappé de Helene, who has been registered at the Montpellier Bar in France since 1993. She worked at the International Commission of Jurists in Geneva before practicing at a Montpellier law firm. She also acquired extensive experience in international criminal law at the International Criminal Tribunal for Rwanda in Arusha, and has developed expertise in the field of human rights and has undertaken a number of assessment missions on the issue of human rights and the administration of justice in various countries throughout Europe and Africa. She has also been responsible for a number of applications before the European Court of Human Rights in Strasbourg. She was appointed in June of 2018 to the post of head of the Defense Office at the Special Tribunal for Lebanon, the STL, by the Secretary General of the United Nations. From 2013 until her appointment at the STL, she was assigned to protect the interests and rights of the accused Hassan Habib Merhi at the STL. And I'm told that Ms. Lefrappé de Helene has been proclaimed an international gender champion committed to promoting gender equality for better governance based on mutual respect and acceptance of differences. She will be speaking to us today about STL archiving and legacy for the defense. Next, we have Dr. Patrick Labuda, an assistant professor of international criminal law at the University of Amsterdam School of Law. Mr. Labuda is a lawyer and historian by training. He earned a PhD in international law from the Graduate Institute of International and Developmental Studies in Geneva, and holds a degree in law and history from Columbia Law School and Adam Mickiewicz University. He is a non-resident fellow of the International Peace Institute, previously held positions at the Fletcher School of Law and Diplomacy, New York University School of Law, Harvard Law School, and Cambridge's Lochterpacht Center for International Law, and the Stellenbosch University, and the Max Planck Institute for Comparative Public Law and International Law. Dr. Labuda is also continuing his research on international criminal tribunals with a focus on how international civil servants and government officials work with, despite or against one another to shape domestic accountability processes. His book, In the Court's Shadow, International Criminal Tribunals and Domestic Accountability, is forthcoming with Oxford University Press. And I'm told that the Swiss National Science Foundation supports his current doctoral and postdoctoral research projects. And he is the author of The Flip Side of Complementarity, Double Jeopardy at the International Criminal Court. And today his topic will be Ne bis in idem in light of the Katanga case, excuse me. And last but not least, we have Mr. Philippe Larochelle, a Canadian-trained attorney and a founding partner of the law firm of Larochelle Avocat, a firm specializing in litigation based in Montreal, Quebec, Canada. Philippe has been practicing as an attorney since 1998, and he has extensive knowledge in civil and criminal cases, including Aboriginal law, both before Canadian and international courts. In 2013, he obtained an acquittal for his Rwandan client, Mr. Mungaware, in a genocide trial before the Canadian domestic courts. Since appearing first in the ICTR in 2001, he has figured prominently at the ICTR, ICC, STL, African Court of Human Rights, and of course the IRMCT. Notably, Philippe represented former Rwandan Minister of Foreign Affairs, Mr. Bikamupeka, and obtained his acquittal before the ICTR in 2011. He has also represented other individuals. At the ICC, he represented Narcisse Arido and has also obtained the appeals chamber confirmation of the decision not to confirm the charges against Mr. Mbarashimana. And he has also appeared at the STL. And I'm told that Philippe is also renowned in Canada and Africa for his skills playing the Canadian sport of hockey, and that he turned down a chance to play hockey today to be here with us and instead talk to us as a legal practitioner. Our loss is the sport of hockey's gain, or do I have that backwards? I don't know. Without further ado, I wish to thank the speakers for their time, and I turn the floor over to Peter, who's first on my list to proceed. Thank you.
Well, good afternoon, everybody. I want to start by congratulating Maria O'Leary and the executive committee of the ADC for putting on this excellent event. I'm sad that I'm having to deliver this talk remotely. The ADC conference is one of my personal favorite moments in the calendar. I think I first attended it during the last century, and I can only hope, in the words of a suitably seasonal song, that one day soon we all will be together if the fates allow. Now, much has already been said and written about the inherent inadequacies of the systems in international criminal law for dealing with the consequences of prosecution in the cases of those acquitted of the charges they faced. The 10 years that Jean-Pierre Bemba spent in custody before he was eventually released in relation to the charges for which he had been placed there is sadly unremarkable. Neither can he complain, unlike his contemporaries at the ICTR, that his living conditions upon release represented anything other than complete liberty. And in truth, he has bounced back pretty well. However, the ICC was supposed to have learned the lessons of the past at the ad hocs. And whilst it championed an end to impunity and the concurrent cause of victims, and it facially at least set out to preserve fair trial rights for accused, and even offered those wrongly accused a statutory route to redress in the form of financial compensation, Bemba stands as a sad lesson learned. Now, whilst the title of this talk is reflective upon events that have occurred, it stands equally as a warning not just to those who fear they might be the target of international prosecutors, but their lawyers too. And the message really must be, don't wait for the dawn raid to arrange your affairs in a manner that best protects you or your client in the case of your lawyers. Now this is where it gets dangerous. I've got to try and share my screen. That seems to be working. Now, just to start off with a little factual background about Jean-Pierre Bemba. He was a vice president of the Democratic Republic of Congo and a president of the Mouvement de Libération de Congo. In 2002, he sent 2 battalions of soldiers to assist the lawfully elected president of the neighboring Central African Republic to fight a military coup. The troops were there for 5 months between 2002 and 2003, and it was alleged that they committed crimes against humanity and war crimes, including murder, rape, and pillage. By the time of trial, some 5,229 victims had come forward. Bemba was arrested in Belgium in 2008, convicted after trial in 2016, but completely acquitted 2 years later. Concurrent to the issue of the arrest warrant, the pre-trial chamber at the ICC issued requests for further assistance in the tracing and freezing of his assets in 3 jurisdictions: the Democratic Republic of Congo, Portugal, and the Kingdom of Belgium. The properties that were seized in those territories were the result of very widely cast requests for further assistance. And whilst nobody has been able to itemize precisely what was frozen, they included property in the names of his wife, his brother, his children, and companies of which he was not even a shareholder. You'll see some of the property there listed. The aircraft in the bottom right-hand corner is in fact the aircraft that was seized at Faro Airport, and it remains there to this day. The buildings there are in fact an earlier version of the terminal, which had been rebuilt around it, but it's still there. What happened to the property? Well, the 6 commercial aircraft were destroyed pretty much forthwith by the authorities in the Democratic Republic of Congo. The aeroplane, not at Lisbon Airport, mistake there, Faro, became unairworthy within about 3 months. The properties in Portugal became dilapidated. The money in the bank accounts remains precisely there, but has developed substantially. The boat is unsaleable. It's perhaps worth reflecting what 10 years in custody means to you, and here are just a few of the headlines. Bemba, of course, missed 10 Christmases, 10 Easters, 70 family birthdays. And as somebody who might realistically have expected to have become the president of the Congo in the decade in which he was in custody, the loss to him of career opportunities is almost incalculable. He lost both of his parents, and even to this day, of course, he is regarded as somebody who was wrongfully acquitted, and so will always be tarred as a war criminal, something which afflicts his wife and children as well. I've mentioned the destruction of his real estate and chattels, but perhaps one of the factors that's less worthwhile, and I'll return to this, is item G. Because his assets were frozen, he had no money to pay his lawyers to defend him. And when he applied for legal aid, the ICC determined that because he had assets, notwithstanding that he couldn't touch them, he was not indigent, and so therefore was not able to apply for legal aid. In the end, Judge Fulford came up with a very sensible compromise, which was that the ICC should lend him the money against his property to pay his lawyers as the trial went on. Now, it's worth just pausing to consider the powers of the ICC to freeze an accused's assets. They arise under Article 93 and also under Article 57 in the case of the pre-trial judge. Article 93 mandates states parties shall provide the following assistance: the identification, tracing, and freezing or seizure of proceeds, property, and assets and instrumentalities of crime for the purpose of eventual forfeiture without prejudice to the rights of bona fide third parties. Article 77.2 deals with what a forfeiture is. In addition to imprisonment, the court may order a fine under the criteria provided for in the Rules of Procedure and Evidence, be a forfeiture of proceeds, property and assets that derive directly or indirectly from that crime without prejudice to the rights of bona fide third parties. Now, of course, it was never suggested in Bemba's case that any of his property or assets were the proceeds of crime. And at least facially, there is an inconsistency in the statute of the ICC between Articles 93 and 57. Only Article 57 mentions the forfeiture of assets for the benefit of victims. And that was the sole basis upon which Bemba's assets were ordered to be frozen, or the requests for freezing orders were made by the pre-trial chamber. I don't suppose anybody would have succeeded in arguing that such requests were unlawful, but in any event, the whole process was dealt with ex parte anyway, so the defence never got the opportunity to suggest that this was an inappropriate course. Now, as I've already said, eventually in 2018, 10 years after his arrest, Bemba was acquitted by the appeals chamber at the ICC. If I have a lingering professional regret about the case, it is that I did not stand up immediately that Judge Christine van der Wijngaard had announced that he was acquitted and request the discharge of the freezing orders. I'm not sure I'd have got anywhere, but certainly it might have expedited the entrenched process that then followed. Following his acquittal, Bemba's attention, of course, turned to the return of his assets, such as they were. There was and still is an abiding sense of denial about his acquittal at the ICC, and the registry was plainly reluctant to fulfill its statutory duty to inform the states about his acquittal. They ultimately had to be compelled to do so. We've never seen the letters. The result of them was that the Democratic Republic of Congo did unfreeze his assets, but obviously not the aircraft which had already been destroyed, so that wasn't the most generous of gestures. The attitude of the registry to the unfreezing of his assets can be expressed in a filing they made at the time. The judicial authority lies with the chamber pursuant to Articles 57.3e and 93.1k of the statute to issue requests for cooperation to impose protective measures on assets at the domestic level. Necessarily also includes the authority to lift such protective measures. Unless otherwise instructed, the registry understands its role in this context to be limited to the transmission of the requests for cooperation between the chamber and the relevant states in accordance with Rule 162 of the rules. But whilst we did not see the letters that the registry sent to the states informing them of Mr. Bemba's acquittal, you can guess pretty much what they would have said from that. They would have said, don't do anything unless the chamber orders you to. Well, we asked the chamber to issue requests for further assistance to the states to unfreeze the assets, and this was the response we got. The cooperation requests issued in this case remain, but cease to have effect in the sense that states are no longer required to comply with them, for instance, by keeping any assets frozen. This, however, does not mean that assets are automatically released in the requested state. It is rather for the state to determine what action to take under domestic law as a result of the conclusion of its obligation to assist the court through the freezing of assets. In other words, the registry is telling the states to wait for the chamber to order it to unfreeze the assets, and the chamber is declining to do so, saying it's a matter for the states to decide whether their obligation is fulfilled. Surprise, surprise, the position of Belgium and Portugal, well, they wouldn't even correspond with Mr. Bemba's lawyers. and it was their position that they would do nothing until required to by the chamber. And so a perfectly circular impasse was created in which Mr. Bemba couldn't get the chamber to request the states to unfreeze his assets. The states wouldn't unfreeze them unless they got an order from the chamber. Well, time was ticking. Mr. Bemba had, under Rule 173, 6 months to bring a compensation claim under Article 85 of the statute. Article 85 provides that anyone who has been the victim of an unlawful arrest or detention shall have an enforceable right to compensation. Firstly, when a person has by a final decision been convicted of a criminal offence, when subsequently his or her conviction has been reversed on the ground newly discovered fact shows conclusively that there's been a miscarriage of justice, the person who has suffered punishment as a result of such conviction shall be compensated according to the law. Well, that obviously didn't apply in Bemba's case. He had to rely on the second ground, which was in exceptional circumstances where the court finds conclusive facts showing that there has been a grave and manifest miscarriage of justice, it may, in its discretion, award compensation according to the criteria provided in the Rules of Procedure and Evidence to a person who has been released from detention following a final decision, acquittal, or a termination of the proceedings for that reason. The procedure which is described in Rule 174 is that a request for compensation and any other written observation by the person filing the request shall be transmitted to the prosecutor, who shall have an opportunity to respond in writing. Any observations by the prosecutor shall be notified to the person filing the request. The chamber designated under Rule 173, Sub-Rule 1, may either hold a hearing or determine the matter on the basis of the request, and any written observations by the prosecutor and the person filing the request. A hearing shall be held if the prosecutor or the person seeking so requests. The procedure in the Bemba case was somewhat different. Firstly, the 6-month time limit, which isn't on the screen but is in Rule 173, was extended expressly to permit Bemba to compute and collate evidence to support a claim for financial loss arising from the negligent mismanagement of his frozen assets. And upon receipt of the claim, pre-trial chamber 2, who'd been appointed to deal with it, ordered that the registry be joined as a party to answer Mr. Bemba's claims relating to the mismanagement of his assets. Just hold that thought for a moment. The basis of Bemba's claim was really threefold. Firstly, he demanded damages for 10 years of unlawful incarceration. And the way in which that was argued was twofold. Firstly, that there was a ready basis for calculation of what 10 years in custody was worth. And 10 years in custody on all the legal authorities around the world, the value of that or the compensation for that really depends very much upon who you are and what your status in life is. I hope that's obvious. You don't compensate somebody who's spent their life being in and out of prison to the same extent you would compensate the Pope, for example. In Bemba's case, there was a ready comparator in that in the parallel Article 70 case, and I'll diverge for a minute. You will probably remember, if you don't, I'll tell you that during the course of his trial, he and some of his lawyers were arrested for offences against the administration of justice. And ultimately, a fine was imposed upon him of several €100,000 with a period in default. This, of course, meant that the ICC had valued Mr. Bemba's liberty quite precisely, and they valued it at €1 million a year. There were also useful precedents in the Florence Hartman case and other cases in which fines have been imposed at the ad hoc tribunals with periods in default. And so we came to the basis, we came to the claim that his incarceration was worth 10 million euros. There were also useful comparative national awards that had, not long prior to the claim being filed, been an award of $14 million to a gentleman in the United States who'd been wrongfully convicted of rape and spent a similar period of time in prison. There was an additional element to the claim for unlawful incarceration, which was a claim for 5 million euros of aggravated damages. And that arose from the principle that the damages for unlawful incarceration are aggravated if the person causing the detention fails to acknowledge that the detention was wrongful. And so it was very helpful of Madame Bensouda to go onto the steps of the International Criminal Court the day of after the announcement of Mr. Bemba's acquittal and effectively tell the world that it was wholly wrong that he'd been acquitted. So the claim for his incarceration with aggravated damages came to $15 million, 50 million euros, I'm sorry. But by far and away, the larger portion of the claim was the claim for the damage to his property from the freezing orders, which had been mismanaged. This was pleaded in the alternative. Firstly, that it was a head of damages that fell properly under Article 85. And secondly, that there was an inherent jurisdiction for the court to provide him with a remedy for the damage which it had caused his property. The financial claim from the damage to the property came to approximately 43 million euros. And that was a very conservative calculation based on expert evidence from accountants and aircraft experts. The principle that the ICC was primarily liable was based upon a body of international protocol and precedent that the person who requests property to be responsible, the person who requests for property to be frozen is ultimately responsible for any loss arising to it, even if they ask somebody else to carry out that freezing for them. In its response, the registry took the opportunity to use the empty chair defense and quite simply throw the states under the bus. Well, the matter was litigated. All parties filed a number of pleadings in the case, and there was an oral hearing. Slide 8 is just an opportunity for me to get something off my chest. At the oral hearing, which was lively, heated, and very interesting, Judge Mindua concluded the proceedings by saying, "I would like to thank everyone for their filings, which were very clear, quite exhaustive, and I would also like to thank you for your pleadings, which have been stellar." A few months later, he was, however, happy to sign off on a judgment which contained this paragraph. The Chamber regrets the choice made by counsel for Mr. Bemba to at times resort, both in addressing the Chamber and in referring to other parties in the court as a whole, to language and tone in some instances of such a nature as to make it questionable whether they can be considered consistent with the professional duties incumbent on all those who are parties to or otherwise involved in the proceedings. Quite a strange inconsistency, you might think. And whilst we're talking of disrespect, I couldn't leave this without showing you how the prosecutor, Mr. Guariglia, finished his submissions. This is a complex matter. It involves, as Mr. Haynes correctly recognized, it involves the court's legal personality. The possibility of bringing a case against the court raises a host of critical legal issues of public international law that, frankly, I am certainly not in a position to answer, in parenthesis, how the hell have you got a chance of doing it, including the court's possible assertion of immunity including which will be the forum for such a claim. This is not something that this chamber should rule on, and I respectfully think there is no need for that. That's as close as you can get, I would suggest, to saying you lot are too stupid to deal with this. But there you go. This is how, in fact, the claim for compensation was resolved. The chamber took the simplistic approach that there was no grave miscarriage of justice, and thus that was really an end to it. As an aside, they said that financial losses were not anticipated by Article 85, and so the claim for the damage to his property could not be brought under that article. And then, quite remarkably, to sidestep the inherent jurisdiction claim, they asserted that they had no mandate to deal with matters of inherent jurisdiction because the president had designated them to deal with an Article 85 claim and nothing else. You will remember I told you to hold the thought that they had extended the time period for the filing of Mr. Bemba's claim so that he could bring in the calculation of his losses, and that they had then invited the registry to take part in the process, notwithstanding that's not envisaged by Article 85 or Rule 174 specifically for that purpose. In response, Bemba's lawyers went back to the president and said, well, if that's the case, will you now designate a chamber to deal with the inherent jurisdiction claim? And he said, no, I will not. The application to the president for the appointment of a fresh trial chamber to examine property issues was refused. So where are we? The position thus is that, how do I stop sharing my screen? Let's go back one, that's probably better. The position is thus that Mr. Bemba's assets, those which have not been destroyed in Belgium and Portugal, remain frozen. He has the option, but has not taken it up, to bring a series of domestic applications to unfreeze his assets in those jurisdictions. I suppose it's possible that either the ICC or the states could bring proceedings to sell his assets within those jurisdictions to satisfy his outstanding loan from the court for his legal fees. But nobody at the moment or seems likely to do that. And there are probably two reasons for it. Firstly, because any claim against Jean-Pierre Bemba by the court or the states would inevitably result in him making a counterclaim for the 43 million losses resulting from the freezing of his assets. And secondly, neither the Belgians nor the Portuguese want to make an enemy of the man who will likely be the next president of the DRC and is sitting on a large share of the world's cobalt and coltan. So there we are. There are many lessons to be learned by this for lawyers in the future. It's a tale which has revealed the ICC does not have the competence nor the experience nor the relationship with its states effectively to freeze and accuse assets. And it is, in any event, doubtful whether freezing orders can be used over a period of a decade whilst a man faces his trial. I think I've probably used my time. It's been a great pleasure to speak to you all, and I hope you found it illuminating.
Thank you very much, Peter. Next on the list, we'll just go in order. So, Madame Dorothy Lefrappé de Helene, I turn the floor over to you.
Okay, thank you, Dragan. Dear colleague, dear friend, hello everybody. It's a pleasure for me to be here today, virtually, but here though. And let me thank first Mary O'Leary and the ADC-ICT for having invited me to discuss with you about the tribunal archiving and legacy for the defense. Two interesting topics related to the defense. It's true that the ADC-ICT and the former ADC-ITTY have set up some positive standards for the defense before international criminal courts and provided types of support to the defense that the Defense Office has always regarded highly and was inspired by. So thank you again for your invitation. As you may all know, the Special Tribunal for Lebanon had to face many challenges over the past year due to the budgetary restrictions and the pandemic. And the Defense Office has been dramatically drawing down in terms of activities and number of people, of staff. So we will complete the appeal proceeding in the main case, the STL 1101, in a few months. And before moving to a dormancy model. So today I have to confess that it's not an easy task to keep you awake after lunch while talking about archiving first, but I will take up the challenge and try to arouse your interest in this topic, which is very specific. It's true and technical, but at least necessary for all of us as defense. So more seriously, I will aim to highlight only few keys elements in that regard, and remain at your disposal if needed for further information. Regarding the second topic about legacy for the defense, I will focus on the STL Defense Office legacy, which is definitely a topic we need to address, I think, today before there is not anymore a running defense office. I will give you some insight today as to what it entails, but let's start first with this archiving issue. Alors, you may know that the defense archiving activities at the Defense Office are governed by the Defense Office regulation on the closing, preservation and destruction of the case file by lead counsel, a regulation adopted by the head of Defense Office on 16 September 2016, in accordance with Rule 58B of the Rules of Procedure and Evidence. Alors, why such a regulation? According to Article 35C of the Directive on the Appointment and Assignment of Defense Counsel, and I quote, lead counsel shall keep a complete and accurate case file of all documentation related to the case and of all work performed by the defense team during the representation of the suspect or accused, and shall retain that case file for 5 years after the completion of proceedings relating to the suspect or accused before the tribunal. Counsel representing the interests and rights of in absentia accused shall retain the case file indefinitely or until it has been handed over to the accused who appears in course or after completion of the in absentia proceedings. Upon counsel request, the head of Defense Office shall provide secure storage facilities for this purpose. Hence, the aim of this regulation was to assist counsel with the closing and preservation of their case file so that it be archived in an orderly fashion and preserved in a safe location. In particular, due to the specificity of this case, which is a terrorism case with very highly sensitive and confidential information and evidence. Where appropriate, it could efficiently be handed over to the accused, to an accused that would appear in accordance with the above mentioned directive, but also the provision of the codes of professional conduct applicable to counsel. So what does this regulation provide for? The regulation provides guidance to counsel to reduce to a minimum the hard copy file to be kept so that the case file be preserved be essentially an electronic one. So far, each defense team's electronic case file has been preserved on two formats. The first is a secure encrypted hard drive, lifespan of approximately 5 years. And the second is LTO tapes, lifespan of approximately 30 years. So most of those electronic files, together with some hard copies case files, are kept in the vault of the defense office, and only counsel or the head of defense counsel in the event of emergency may have access to the case file. The case files may also be stored by lead counsel at his or her professional domicile under the strict respect of confidentiality of the non-public information, because we need also to remember that it's a terrorism case and very sensitive case. It must be noted that with regards to the length of the preservation of the case file, the regulation also adds the possibility for the head of defense office, in consultation with counsel, to determine a specific time frame for the preservation of the in absentia case files, shorter than the indefinite period provided under the directive. It is yet to be determined where and how defense teams' archives will be stored after the completion of the appeal proceedings in the main case and transition process thereafter, upon the expiration of the tribunal mandate. In the meantime, they will be stored separately from the rest of the tribunal's records. The defense teams' archiving activities are covered by the legal aid policy of the defense. Why? Given its institutional position, the defense office was well placed to provide guidance and resources to the defense teams for the closing and preservation of their case file, as well as ensuring oversight and appropriate use of public funds. In that respect, and arising from the experience of the termination of the proceedings in the Badreddin case following his death in 2016, the Defense Office recognized that the tremendous volume of material in the case, subject to archiving, and the substantial work entailed would benefit from a two-step archiving process, and that it was reasonable and necessary to pay counsel for such activities. Therefore, the legal aid policy was amended to include preliminary archiving activities as of the deliberation phase and prior to the rendering of the judgment, which is usually a long period with limited judicial activities. And it was done in comparison with other tribunals' experience. In the main case, STL 1101, the final archiving for two defense teams, the Honesty and Merit teams, will be undertaken within 1 month following the rendering of the appeal judgment. Regarding the Defense Office by itself archiving activities, over the upcoming months, the Defense Office will also continue archiving its digital and physical records in line with the tribunal's policies. Now I will turn to the second topic on legacy. Alors, the Defense Office legacy, I think that what is important to have in mind is the fact that it, for the first time in history of international criminal courts and tribunal, at the Special Tribunal for Lebanon, a Defense Office has been established as an independent organ at the same level that the three other organs, which are the president, the chambers, the prosecutor, and the registry. And its function and structure make it unique in the international legal landscape. Its legacy stems from the way the Defense Office decided to implement the attribution it had under the statutes and the rules of procedure and evidence, which means that the Defense Office acted and acts in a dynamic and constructive manner within such parameters, with the aim of always make sure that the interest of the defense be heard and understood by its stakeholders within and outside the tribunal. The contribution of the Defense Office at the institutional level of the tribunal is a big part of its legacy. As you know, the Defense Office, although fully independent, including free of any registry's supervision, is an integral part of the tribunal. This means that in addition to the adoption of a substantial contribution to defense regulating documents, the head of Defense Office is a member of the Rules Committee, which deals with the amendments of the rules of procedure and evidence. And the Defense Office contributed to many of the regulating documents of the tribunal. In addition, the Defense Office, through me or one of my representatives, participate to all inter-organ working groups dealing with specific topics, such as the setup of the legal workflow, the transition planning of the tribunal. Moreover, the head of Defense Office is a member of the senior management board alongside the president, the prosecutor, and the registrar. In that capacity, my predecessor and I participated in all top-level management discussions of the tribunal. This has allowed us to vigorously defend and represent the interest of the defense internally at the institutional level. It is important to note that externally, the head of Defense Office has the exact same access as the president, the registry, and the prosecutor to the members of the management committee, the Lebanese government, the Office of Legal Affairs of the UN, and the diplomatic community in Lebanon, New York, and The Hague. During these contacts, which were regular, the Defense Office promoted the importance of the role of the defense in international criminal proceedings, and has also explained and when needed, defended the defense needs for cooperation and or financial support from states. In short, the head of Defense Office enjoy a much greater parity in status and treatment with the prosecutor, which is a big step forward for the defense at the international criminal level generally, and more specifically, an inspiration for potential reform of the defense structure at the ICC, for example, which is currently being considered. Over the years, the Defense Office assisted legally, financially, and logistically 8 defense teams in the different cases, which were STL 1101, STL 1801, STL 1406, STL 1405. Although for the latter, only in part as team, the team was appointed and financed by the two accused. This totaled 22 counsel and approximately 30% assisting counsel over a period running from February 2012 up to now. I would say that the legacy for the Defense Office, I will develop, I think, 4 points, 4 essential points. The support provided to the team in terms of human resources and facilities. That's the first legacy. The Defense Office ensured that the representation of the accused by counsel met internationally recognized standard of practice. This included, but it was not limited to, allocating funds to the defense team to provide them with the resource necessary for the performance of their duties and the preparation of their case. It included human resources, facilities, IT equipment, software. In that respect, the head of Defense Office adopted and implemented the legal aid policy for the defense, which provides for the payment of defense counsel and person assisting counsel who are assigned to represent indigent or partially indigent suspect or accused before the tribunal, as well as accused in absentia. The legal aid policy was implemented on a daily basis by the legal aid unit, which was also in charge of preparing the budget of the Defense Office. The independent management and implementation by the Defense Office of the defense budget and the legal aid policy were crucial to properly addressing the specific needs of the defense teams, as well as ensuring or trying to ensuring equality of arms with the prosecution. The legal aid policy proved to be an effective tool throughout the 3 phases of the proceedings. It served as a roadmap guiding the Defense Office to progressively reduce its budget and gradually downsize the defense staff while moving towards the end of proceedings. It is worth mentioning at this stage that person assisting defense counsel were full staff members of the tribunal, which is also a novelty. Just like other staff of the tribunal, including the prosecution staff, registry staff, their employment was governed by the STL staff regulation and rules, including recruitment, entitlement, and termination of contracts. Defense staff members could also be staff union members. This status did not affect the independence of counsel and their teams toward the tribunal, and contributed, on the contrary, to a better understanding of the work of the defense within the tribunal. The legacy is also related to legal assistance and training for counsel. Through its legal advisory section, the Defense Office responded to hundreds of requests for legal assistance from the defense teams in all the cases before the Special Tribunal for Lebanon. The legal advisory section conducted legal research and prepared legal memoranda on various questions related to the applicable law and procedure. It also provided a weekly review of the judicial developments in all cases before international tribunals. The Defense Office organized and conducted several trainings on the STL applicable law and procedure for counsel from various legal backgrounds who were admitted on the STL Defense Counsel list, and provided a continuing training to assign defense counsel. The organization of such training by the Defense Office was done independently with our own defense budget. At the STL, the registry, far from objecting to such training organized independently by the Defense Office, to the contrary, supported them by providing the necessary facilities, room, equipment, human resources, interpretation services, and so on. So it was something very valuable for all defense counsel.
Apologies, we're coming up to the time limit.
Okay, I'm done. Then there was also a support for the defense team's investigation, which was also very important because the Defense Office was able to engage in the conclusion of memorandum of understanding with Lebanese authorities, and which allow the defense teams to investigate in Lebanon. This memorandum was signed in July 2010. And of relevance in this regard is the creation of a liaison officer position in Lebanon that allowed us to maintain a relationship with Lebanese authorities and implement as effectively as possible this MOU. And in addition, this cooperation, all the defense cooperation requests went through the liaison officer who assisted the defense teams with the planning of mission as well. So it was a save of time and resources for the defense. We also contributed with a lot of external events for the outreach, and I would mention a big legacy for us, which are some documents we provided at the Defense Office. And I would mention the Practitioner's Handbook on Defense Investigation, the digest of the case law of the STL, and the Manual for Defense Counsel Practicing Before STL. We also organize a series of From Defense to Defense roundtables in collaboration with the OPCD of the ICC on different topics of interest for the defense. What is important is every year we organize the annual international meetings of the defense since 2013, where all of us could discuss about issues of importance for the defense. And by the way, I would like to say that, for instance, the Practitioner's Handbook on Defense Investigation I just mentioned is a concrete result of two of those international meetings, Geneva and London, where needs were identified to concerning the investigation led by the defense and solution proposed. So in conclusion, and sorry, I was too long, but I need to plea for my Defense Office. What will remain after the closure of the STL? What are the lessons learned for us as Defense Office? I would say that this status as an independent organ has proved to be one of the STL best practices. It enabled it to provide all the support and assistance necessary to defense teams tailored to their specific needs, and it provides also a way to express our concern before the diplomatic community and to have a voice for the defense towards them. It gave also person assisting defense counsel the status of full staff members of the tribunal with the same rights and entitlements that any other staff of the tribunal, and it contributed to rebalance the principle of equality of arms with the prosecution. And last but not least, it's the first international tribunal created for an Arabic country and in the Middle East and North African region, and which has jurisdiction over the crime of terrorism. So all these specific features are part of the legacy of the Defense Office and more broadly the Special Tribunal for Lebanon. Thank you, and sorry, I was too long.
Thank you very much. Professor Labuda, if you'd be so kind to take the floor now, it is yours.
Good afternoon, everyone. So let me begin by thanking the organizers for the opportunity to be here. It is a real pleasure, and I hope that next year we can do it in person. So I too have a PowerPoint. Let me try to upload it. Does everyone see that? Yeah, it's working. Okay. So I've been asked by the organizers to discuss the prohibition of double jeopardy, or nabis in idem, as is more commonly known outside the Anglo-Saxon world. And more specifically, I will be discussing the issue of nabis in idem in international criminal law against the backdrop of the case of Germain Katonga. So most of you will be familiar with the ICC's trial Jean-Marc Katonga and Mathieu Ngujolo, which ended rather ignominiously for the ICC prosecutor. Ngujolo was acquitted, of course, and Katanga was convicted for crimes committed during an attack on the village of Bogoro in eastern DRC in 2003. And here you have Kevin John Heller's assessment of this conviction. So his conviction on these charges really happened after a controversial application of Regulation 55 at the very end of his trial, when the chamber recharacterized the facts to find Katanga guilty as an accessory, only an accessory under Article 25, 3D of the Rome Statute. Now, I must confess that sort of my involvement with the Katanga case began rather late, well after his ICC trial had ended in 2014. I mean, I had been aware of the ICC's trial against Katanga, but I'd never really paid that much attention to it. And in particular, I'd never really engaged with the legal issues, the legal aspects of his case. I came to the Katanga case a bit later, around 2015, 2016, when I was conducting field research in the Democratic Republic of Congo for my PhD, which, as you heard, will be soon hopefully published as a book. And it's a bit funny almost, because I now teach primarily doctrinal international criminal law at the University of Amsterdam, but I am first and foremost, I think, a socio-legal scholar who studies how different legal and political actors use international norms, international criminal norms, to accomplish policy goals. And in the context of my broader socio-legal research in the DRC, around 2016, I became interested in the DRC government's reasons, both official and unofficial, for wanting to re-prosecute Katanga despite his conviction in The Hague. And so I visited Germain in Makala prison. This is a photo of Makala prison in the capital in Kinshasa. This is also a trial that's taking place. I monitored trials there over a decade ago when I worked in the DR Congo for the EU. But so he was being detained in not far from this prison room. I mean, it's a makeshift courtroom also, but this is actually inside the prison. And so I visited him there in 2016, and this was actually right after he had found out about the ICC presidency's decision to authorize his domestic trial, his retrial in Kinshasa by the High Military Court. And I also interviewed at that time members of the Congolese Military Prosecution Service and the government, the Congolese government, to get a better sense of why his domestic trial was going ahead. And I should probably disclose that some of my views on the Katanga case are influenced by my empirical research in the DRC. And more generally, I think it's safe to say that my outlook on international criminal law is heavily influenced by many years of engaging with the effects of various international criminal tribunals in a variety of African countries. So not just the DRC, but also the Central African Republic, Sudan, South Sudan, Rwanda, Sierra Leone, and Libya. So with that background out of the way, here you have the facts of Katanga's case. But with that background information out of the way, I turn to really the legal part of my presentation, where I want to discuss the ICC presidency's flawed decision to authorize Katanga's secondary trial, retrial. I call it a retrial in the DRC. And I think it makes sense really to get two things out of the way right off the bat. The first is that the presidency authorized Katanga's domestic trial despite the prohibition of ne bis in idem. And the second fact that I think is important is that Katanga was, of course, ultimately never re-prosecuted, never retried in the DRC, He was released as part of a government-backed peace agreement involving his former rebel group in March 2020, which means that he spent 4 additional years in Makala prison, awaiting a trial that would never happen, which the ICC presidency could and should have known when it authorized his domestic trial, if only the ICC presidency had any interest in actually knowing anything about his domestic trial. But as I will try to show in this presentation, the ICC presidency never wanted to know anything. So let me turn to that decision, and I'll just focus on a few issues arising from this case. With a particular focus again on nebis and idem. Here you have sort of as background the prohibition of nebis and idem, which is in Article 21 of the Rome Statute. First, you have downward nebis and idem.
J'ai payé puis c'est enregistré, je peux le réécouter.
I think somebody has unmuted themselves. Yeah, so the first issue, so the first provision, this is Article 21, paragraph 2, you have downward nebis and idem. And then, so downward nebis and idem is when there's the question, so the question here is, when is a national trial permissible after an ICC trial has already occurred? And this is the Katanga case. And then the more famous provision that you'll be familiar with is Article 21.3, which is upward nebis and idem. So what are the conditions? When can the ICC try someone who has already previously been tried domestically? And of course, you have the 2 complementarity exceptions, shielding the person concerned, and trials not conducted independently or impartially. I've also highlighted the different standards in paragraph 2. So for a crime, and paragraph 3 with respect to the same conduct. And I'll come back to this in a moment. You know, one thing to point out is that paragraph 2 that is relevant for us, it's declaratory in nature. So in theory, if the DRC decides to, or any other state party decides to prosecute somebody who's already been tried by the ICC has no power to compel a state to abide by its decision. So the ICC just doesn't have enforcement powers to make a state comply with Article 21.2. And so that would be the situation. That would be Katanga's situation, but Katanga's situation also implicates a different provision in the Rome Statute, and that's Article 108, which deals with situations when a state party wants to prosecute a defendant who is serving a sentence imposed by the ICC in its territory. And so in this case, a state party which has agreed to receive someone convicted by the ICC cannot simply decide for itself that it wants to prosecute the person it has agreed to receive, unless the ICC approves such a prosecution. So that's very different from Article 21.2. And I've highlighted here for any conduct which is different from the standard in Article 21.2. So this is exactly Katanga's situation. He was sent back to the DR Congo to serve the last few months of his 12-year sentence in late 2015. And a few months after his transfer, as he was awaiting his release from Makala prison, the Congolese authorities announced suddenly that they would not actually release him, and instead they would prosecute Katanga domestically. And the DRC's announcement was problematic for a variety of political reasons that I don't want to get into in this presentation. I want us to focus a little bit on the legal issues, but I'm happy to discuss the politics also. The bottom line is that in April 2016, the ICC presidency authorized Katanga's domestic trial. And here you have the relevant part of that decision. I've highlighted a few things that I think are important. I mean, the presidency disingenuously says that there are no relevant criteria in the Rome Statute for its decision. That's inaccurate, but they do this for a reason, and I'll come to those reasons in a moment. Basically, the bottom line here is, again, that secondary trials are not the exception according to the presidency. They say that they are generally permitted, and only in exceptional circumstances will they prevent a state from re-prosecuting people who have previously been tried by the ICC. And I think that this decision is wrong for several interrelated reasons, and I'll focus on just three. The first point to raise is that the presidency really refuses to address the issue of Katanga's domestic trial through a human rights fair trial lens, but instead focuses on wider systemic questions, and in particular, the issue of complementarity. This is concerning not only because of Article 21, paragraph 3 of the Rome Statute, which is, of course, the catch-all provision that makes it mandatory for the judges to interpret the statute in conformity with human rights. The presidency's position is concerning because Article 108, which the judges were applying in this case, is really all about ensuring compliance with human rights. Article 108 is based on the principle of specialty in extradition law that makes extradition and prosecution contingent on a state's respect for fair trial rights. And the presidency simply ignores this context. It ignores the object and purpose of this provision, Article 108, and falls back on the ICC's jurisprudence about complementarity, which, filtered, of course, through the Libya cases, makes human rights considerations secondary for complementarity assessments. So because the presidency decides that it can essentially ignore the text and purpose of Article 108, that makes human rights the core issue here, that Article 108 is read down to reconcile it with the ICC's case law on complementarity, rather than the other way around, adjusting the ICC's complementarity case law to make it compatible with Article 108, which is the legal basis for the current decision. The second point that I want to make is about ne bis in idem specifically. So here the ICC presidency, again, even though it distorts the legal foundation of its decision on whether to authorize Katanga's domestic trial, the presidency does acknowledge that a violation of ne bis in idem would be going too far. So if the DRC really tried to relitigate the same issues that were already litigated in The Hague, the presidency would say no, because there would be, of course, this violation of ne bis in idem. And so you would think that the presidency would then give us some interesting reasons, some case law on ne bis in idem, and you'd be wrong if you thought that, because the presidency doesn't bother to do any analysis of the DRC's domestic case against Katanga, or how it relates to his ICC trial. The presidency's argument can be summarized as follows: the DRC has assured us that it is not prosecuting the same case, so we are satisfied that it is not prosecuting the same case. You promise that you're not going to prosecute him for the same case. We believe you. We will not perform any further analysis of ne bis in idem. And there are two major problems with this. First of all, there is a clear violation of ne bis in idem with respect to some of the charges at the domestic level. The DRC wants to prosecute the enlistment and use of child soldiers. Katanga was acquitted on that charge at the ICC. But the ICC presidency pretends not to see that. Instead, they say there are other issues that are different from the ICC trial. So from the charges brought before the ICC, the attack happened in Bogoro. That's the attack that was at the heart of the ICC trial. And there are some issues that are different from Bogoro, and therefore we're not going to analyze any of it, including the charge of enlistment and use of child soldiers. And we're not going to tell the DRC that you violated the principle of ne bis in idem with respect to those charges, because some of the charges maybe are different. maybe is the key word. I'm not going to get into this because we don't have enough time, but it's controversial. The other thing to point out is that, and this is a bigger problem, the defense, Katanga's defense raises this issue that the DRC didn't actually have a case against Katanga at the domestic level. They relied on the information that the OTP, the ICC prosecutor, had sent back, information that the prosecutor had not used against Katanga in his ICC trial. So the DRC receives that information and they rely on that information to claim that they are going to prosecute Katanga, but they don't have anything except that, or anything beyond that information received by received from the ICC prosecutor. And so there's really an interesting question here that, again, the presidency doesn't get into, and I'm not going to unpack further, but sort of, you know, how does that work, right? Where's your domestic investigation if you're relying on only information received from the ICC prosecutor? Right, the last point that I want to make here very briefly, and I won't get into this, is that even if we accept for the sake of argument that even if we accept for the sake of argument the ICC presidency's logic that the issue of secondary domestic trials against ICC defendants should be filtered through complementarity and not the defendant's right to a fair trial. So even if we accept that framing, the presidency in this case gets the complementarity analysis wrong. And I can come back to this maybe later, but their assessment of complementarity, and I addressed this in the article that Dragan mentioned at the beginning. I talk about this a little more, how they get the complementarity analysis wrong, basically to say that we're never going to intervene and try to monitor what a state is doing at the national level. And again, it's too deferential to the state, and there's no reason to do that. It's a missed opportunity to put a little pressure on the DRC for them to actually comply with fair trial rights. But again, I won't get into that. I want to wrap up. Just tell you a few words about what I think are the broader implications of this case. The first one, prudential, I disagree with the ICC presidency when it says that it should only intervene if its integrity is at stake. And the ICC's integrity will be implicated or will be sort of, you know, an issue if states are, I can't even see my slide here. If states are allowed to re-prosecute defendants when they are dissatisfied with the outcomes of ICC trials, if this keeps happening on a regular basis, of course, there will be a real issue here. And we've seen this not only in the DRC, but also in other countries. There's a systemic issue with complementarity that, again, I'm not going to get into right now, but I'm happy to discuss later if there are questions. The last point that I want to say, or the last point that I want to make here, is about how human rights and fair trial standards are applied by the ICC. There really is a bit of an irony here because you know, that Article 21.3, we think of this as, you know, sort of the catch-all provision that ensures that human rights are taken into consideration at the ICC. And one would think that this provision could be used to protect the fair trial rights of defendants. In these cases, the presidency, the judges refuse to engage with fair trial rights when it comes to sort of if that were to be used to protect the defendant, but they're very happy to invoke, so the judges are very happy to invoke human rights standards and fair trial rights when they have an interest in doing that. And I've listed here the Gaddafi complementarity challenge from 2019. So this is the less famous complementarity challenge that happened many years after the famous litigation between 2012 and 2015, or 2014, 2015. This was Gaddafi arguing that he had already been tried, which is true. He was tried and convicted in Libya, and therefore his case had become inadmissible before the ICC. And in that case, the pre-trial chamber was very happy to look at human rights law, human rights jurisprudence, to come to the conclusion that the domestic trial lacked finality. So there was no ne bis in idem issue, and therefore his case remained admissible. And I just find it really ironic how human rights are ignored when it's convenient for the ICC judges, especially when it comes to complementarity assessments. But when it is, so when it's inconvenient, they ignore it. But when it's convenient and they want to keep a case, like in this case, maintain the admissibility of Saif Gaddafi's ICC case, they turn to human rights, and there's no shame. There's no shame. Human rights become sort of the conceptual filter through which they analyze complementarity. So there's really a cognitive dissonance there, I find, which is worth thinking about. And I think I'll stop there. If you have any questions, I'll be happy to discuss in the Q&A.
Thank you very much, Professor. Philippe, it's your turn.
Oui, bon après-midi à tout le monde. Thank you. I would like to thank the ADC for having me here on the panel today to talk about issues pertaining to epilogue to proceedings. What happens next? I want to talk about ICTR leftovers and how the residual mechanism deals with it. And I'm interested in talking about two particular classes of leftovers. The first one is evidence, and the second one I will be talking about is those judicial corpses left at the end of those trials. With regards to the evidence, I want to talk to you about issues arising out of having access to the evidence detained by the prosecutor through the lens of the Mungwarere case, which I defended in Canada. Mungwarere was arrested on the 6th of November 2009, and he was acquitted on the 5th of July 2013. This case concerns accusations of genocide that took place in the prefecture of Kibuye in Rwanda. The ICTR has prosecuted several cases in the area of Kibuye. There was that of Kaishema in Ruzendana, that of Takutsirimana, father and son, that of Nitegeka, that of Munyakazi, that of Musema. So there's a rich history of litigating cases in the Kibuye prefecture. One of the reasons being that the famous Bisesero area is included in that area. There is also, I mean, those are other difficulties, but there was also a case prosecuted in Holland, the case of Mpambara. There was a case prosecuted in the United States of America, the case of Enos Kagaba. And so Mungwarere arrived after that long list of cases. And just for the history, he became a genocide suspect after he was announced as the first defense witness in the Enos Kagaba case in the United States. The day after is when the first statements against him were generated by the 6 Rwandan prosecution witnesses that had been brought to the United States to testify against Enos Kagaba. So the fact that there was a rich history of cases at the ICTR preceding the Mungwarere case meant that there was a lot of material that was detained by the prosecutor. The prosecutor has some database or has statements, results of investigation, transcripts, documentary evidence, radio tapes, sort of a Death Star, which he uses to prosecute accused as they come before the tribunal. And unfortunately, it's very difficult to have access to that Death Star because there are limitations in the current policies for people who are defending people in local jurisdiction to have access to that material. There are two policies which could allow lawyers to have access to that information. The first one is a policy called MIG-13, Prosecution Regulation Number 2, which deals with having access to protected material. Unfortunately, only national prosecution authorities can have resort to that policy to seek information from the ICTR. The other policy that might could have been helpful is the access policy for the records held by the International Residual Mechanism, which is MIC 17/Rev, dated 4th of January 2019. But that policy does not cover protected materials such as redacted transcripts or confidential witness statements, which really were the material that we needed in order to be able to do that case. We insisted a lot with the prosecutor to use his power under that prosecution regulation number 2 to have access to the material. We obtained some of the evidence that we wanted, but unfortunately not all of it. And at the time, not being aware of the existence of all of these policies, we filed directly with the ICTR to try to have access to that material, only to be told that we had no standing before the court to seek that material. And we were completely dependent on the goodwill of the prosecutor to be able to access that material. Nevertheless, the information we obtained was enough to demonstrate the fabricated nature of the case against Mungu Arere. The number of anecdotes I could tell you about that case would take me more than 15 minutes. But I'll give you one example, which I find striking. There was this famous witness, Tip 103, who had testified in maybe 3 or 4 cases at the ICTR and provided 12 statements to the ICTR when he was first met by the poor Canadian investigator who had no idea of the rich history of giving statement of that witness. And when we were appointed in Mungu Arere, we told the prosecutor that there was a risk that this whole case might be fabricated, that he should be aware of that. So to prevent them from that, their idea was to ask the most open possible questions to their witnesses. So when they came to meet Tip 103, the guy who had given 12 statements and testified in 4 cases at the ICTR and never a single time mentioned the name of Mungu Arere, gave a statement of 120 pages where he only talks about Mungu Arere. And he even has the guts towards the middle of that statement to ask the investigator that he would like to know who exactly is the person they are investigating. And that was triggered by a question, such a question was talked to us about the genocide, where you were and what you saw. So the fact that the prosecutor was not already in possession of the material, the past material of that person, actually caused a great deal of judicial waste and judicial resources, because if you had been in possession of this material, it was clear that this guy was, telling the richest story possible with, of course, when he saw these Canadian investigators coming in their white Nissan patrols, his idea was made that he wanted to come to Canada to testify and possibly stay here to seek asylum. So a poor story, really. The acquittal of Mungu Arere, the judge accepted that large portions of the case against him were completely fabricated. Proper cooperation between the prosecutor and national authorities could have prevented that disaster. So it's one thing on the side of the national authorities to seek that material. What I find to be unforgivable is the fact that the prosecutor at the ICTR or at the MIC are not proactive at all in reaching out to national prosecution authorities and securing that material. And I know that because Mungu Arere, the witnesses that came there, also one of them was underpinning the conviction of Ntaku Tsirimana for murder, and he recanted his testimony and accepted that he had lied in the case of Ntaku Tsirimana and that he had Ntaku Tsirimana had never killed the accountant of the hospital. So I myself launched a review proceeding for Ntaku Tsirimana, only to be opposed by the prosecution on the ground that I was convicted in seeking out such a review, because the witness who had recanted in the Canadian case was my witness. Anyway, out of fatigue of fighting with these guys, I just passed the case to someone else who's currently pursuing it today. Another review case arising out of the Mungu Arere case was that of Nitegeka. In that case, a guy who had Nitegeka convicted for the murders of 2 specific persons on a specific date at a specific location had forgotten that when he met the investigators of Canada for the first time, and divided these 2 murders in 2, attributing one to Mungu Arere. So again, this time, another review proceeding launched in the case of Nitegeka. There were way more issues arising out of the case of Mungu Arere that possibly affected the outcome of the case of Nitegeka. But unfortunately, Nitegeka died during the review process, so we were never able to take it to its end. So what I want to denounce here is the fact that when you work on both sides of the board and you do cases before national courts and you have done cases at the ICTR, you realize that the areas of intersection of these cases are very important. And unfortunately, a great amount, I've been involved in other local cases, more recently in Sweden, for example, where I noticed that the local authority, the local prosecutor had not even sought to try to obtain material from the prosecutor. This is a case in the Butare prefecture, another case which is another area which had led to numerous cases before the ICTR, and no efforts whatsoever were made by the Swedish prosecutor to obtain material coming from Butare. So I think that, first of all, there is a gap to bridge between the two policies I mentioned before, in as much as there should be a possibility for lawyers who are involved in genocide cases, especially regarding Rwanda. There's a rich, they continue to pop in many countries. So we see a lot of cases still today. The fact that lawyers involved in those cases at the local level have no leverage or no access whatsoever to the material, the Death Star of the prosecution is actually jeopardize fair trial rights of the people who have genocide cases in local jurisdictions. So that's one of the things I wanted to raise. The second matter I wanted to raise is that of the relocation of the judicial corpses still in Arusha after their acquittal, there's 5 of them, or their release, that for which there are 4 of them. So you will hear in the upcoming days that the registrar has managed to secure the relocation of some of these guys. I'm privy to these negotiations, not negotiations, sorry, I'm privy to this process because there's no negotiations involved really. And I think it's a real problematic issue that is arising out of this process. It's a unilateral decision and exercise that has been done by the registrar in this case. It's all very confidential, so I'm a bit at difficulty here to reveal any of it, but I can just say that the outcome is the imposition of a unilateral decision, which will have the impact or the effect of degrading the conditions in which these guys are currently are. So what I want to say is that there is a need for more transparency in how the whole thing unfolded, because these poor men were put with that possibility, if we can call it as such, with very little time, very little facilities, very little room for discussion, no consultation whatsoever. So it raises the question in terms of maybe indigency is a blessing in the case of these guys, after hearing what Peter Hines said earlier. They have no money. My client, for example, Jérôme Bichampaka, is 64 years old. He's been arrested in 1999. He's been detained for 12 years before being acquitted. He spent another 10 years in Arusha. His wife and kids are in Montreal. He's now sick. So they want to, the idea is to move him in the midst of cancer treatments that he has to undertake in a different country. So you can imagine the level of stress and anxiety that also bring to him. So the issue is novel. So to what extent, what right do they have to be consulted? Is the registry entitled to affect in such a negative way their living conditions? Those questions may very well become alive in the upcoming weeks because of what is currently taking place here. So, but I have no doubt that you will hear more in the upcoming days or weeks about what is taking place. So I may stop here and maybe leave some time or an overtime, since we were talking about hockey, an overtime for questions if anybody wants to know more about disrelocation business or access to evidence from local jurisdictions to the ICTR Death Star. So I thank you very much for your attention, and I hope you were able to grasp some useful things in my little expose.
Thank you very much. And indeed, we appear to have time for perhaps one question or maybe two. Does anyone from the audience have a question? I'm not seeing anything right now. We have a question from the audience. How does ne bis in idem function at the IRMCT? What kind of cooperation exists between states? I've lost the anyone want to tackle that question that's in the comments?
I haven't looked at ne bis in idem before the ad hoc tribunal, so I'm really not in a position to comment on that.
Perhaps a follow-up to that might be more accessible. Given the propensity to use the mode of liability of joint criminal enterprise in these international cases, where the evidence presented is often just a snapshot or illustration of selected crimes of a widespread and systematic campaign, what are the implications of ne bis in idem, and particularly as we looked at the ICC Article 108 and Article 20, subsection 2, as to same crime or same conduct?
All I can say about that, just very briefly, maybe others want to jump in and comment. My concern with the decision that I analyzed specifically here is that in this case the presidency, right? So it wasn't a panel of judges, a pre-trial chamber or trial chamber, appeals chamber, but the presidency in this case just declined to even engage in this conversation, which I think was a missed opportunity, because here there wasn't really such there wasn't an issue with the mode of liability specifically. With Katanga, that wasn't a problem, but they refused to sort of share their views on how one should go about assessing ne bis in idem, the sort of the constitutive elements of ne bis in idem at all. Yeah, so I think that was a missed opportunity, but they didn't say anything about modes of liability specifically.
Okay. Do we have any other questions, or is everyone fulfilled with the knowledge that they've gained? Well, I'm seeing no more questions, so I would take this opportunity to thank the members of the panel for their presentations, and I would like to turn the floor over to President O'Leary for the closing remarks. Thank you very much, everyone.
Voila, there I am, and there you are. And thanks for sticking with us through this great day. And thank you so much for all of this. Yes, I have definitely found enough information from the course of the day. In particular, I feel like we've had this movable feast that's gone from in-person to online. And frankly, I am stuffed with food for thought. So this huge thank you to the speakers and the moderators today for serving this three-course banquet. All of you out there generously giving of your time and wisdom. A big thank you to you for participating today, for adding the spices and flavors that we had to today's with interventions and joining the breakout rooms. I really enjoyed the breakout rooms. I don't know if any of you had a chance to go, but I got to see some people I haven't seen in a while, got to meet some new people and some people I see all the time. But either way, it was fantastic. It was a fantastic experience. And thank you all to giving your Saturday for these really important topics. If we go through them, we learned quite a bit today from all of the panels. If I go back, I have tons and tons of notes. And in fact, yesterday I read an article about exhaustion and how people are hanging on by a thread, but I don't believe it in what I saw today, because I'm thrilled. These discussions were, as Marianne said at the very first panel, a deep dive into what a defense counsel is, what being a defense counsel means. Kate gave us something about if acquittals are seen in the negative, does it seem fair to the person who is the defendant in the proceedings? And answered about, what is the point here? She at one point said something about, maybe she's defining an unrealistic utopia, but that was the call today, wasn't it? Stefan joined us in talking about some of the practicalities that we had with Article 13 and 14 of the ICC and the UN veto powers and the practical ramifications, and suggested maybe a move to use regional courts to assist fairness. Though, of course, it came back into a really interesting topic about that hot potato and what would actually be possible in the time of any given context with some of the interventions we had there. Some discussion about whether or not, use of truth and reconciliation committees or commissions can actually be something that can help us through this process. Kieran took us to Spain for Sunshine, so thank you for that, and a bit of a tour of universal jurisdiction and how that plays into all of this, and the political considerations in favor of, potentially inexpensive proceedings and a lack of clarity that may occur within universal jurisdiction. Andy then, of course, led us into a discussion on evidence, moderating the panel very expertly with Judge Corner talking about the necessity of having insider witnesses. Is the evidence faulty? She said almost certainly, but does it fail justice? And gave a qualified no on that. The question she put is that, can the witness actually tell the truth? We got to hear from Wayne Jordash about, he started with a spot of religion, but that was brought by way of a decision, and talked about the importance of fulfilling the goals of the institution set out to do, in particular when you're talking about historical records. Felicity Garrity very kindly talked about what does faulty mean when we titled that. It's a very good question to contextualize what it means. And she managed to do so with cases. And is there proper disclosure? And if there's not, do we stop everything? Melinda wanted to know, of course. Melinda gave us a fabulous quiz at the end of hers, which I found very enlightening, thought-provoking, but asked us to ask ourselves the question of, are low-hanging fruit poisonous? And can you participate if the fruit is poisonous? So it's something actually that we all have to think about. Panel 3, of course, this afternoon after the lunch break and after a couple breakout rooms, Danny led us into this discussion of the epilogue and what happens next, which Peter gave us a pretty good true cost of acquittal, as he titled it, by a tour through the case of Mr. Bemba after the Bemba case. And as with their filings that they had in that case, we really had a contextualized human element, the human of the defendant in the proceedings of the case, and the life that it took there. The Madam Head of Office of the Defense Office, Ms. Dorothée, gave us, as she said, the big task of talking about archiving legacy after lunch, but she did so masterfully in talking about all of the considerations that went on there and the inclusiveness of the defense, summarizing that the lessons learned was one, that a defense organ was one of the STL's best practices. We have new contributions, it seems. And when we get to then, of course, Professor Labuda talking about an in-depth analysis of Nebis and Idem jurisprudence as developed the Katanga case and the challenges to what he termed as a new trial. And of course, finally, rounding out with Philippe and the review cases. And we came full circle back to discussing some of those elements of universal jurisdiction. What does it all mean in the great context of it? So all of this is just to say we have so much to think about now going into the evening. It's about 4:15. We're just about to round this out. And I just want to thank everyone for all of those fabulous contributions. Personally, I owe an enormous thank you to the ADC Executive Committee. That would be Kate Gibson, Danny Ivatich, Gregor Guy-Smith, Jeff Roberts. Thank you so much for all of the work you put into this. And of course, the magnificent training committee I get to work with, Colleen Rohan and Danny Ivatich. And for those who say, well, they say, oh, the ADC basically runs itself now. It does not. We have a DOM for that. the incomparable, always one step ahead of our questions, Dominic Kennedy, who has made all of the logistics of this possible and technical. All of those, can we do this questions were answered with a yes, and the details were covered by his care. Normally at this point in time, we'd hand over a gift, and honestly, I have one for him here, right here, very festive. But maybe if I try to put it through the camera, see if I can do that. Let's see if that actually maybe works. Dom, are you around? Can you maybe?
I'm ready in here.
Give us a wave. Oh, perfect. Wonderful. Thank you to Dom, from everyone, from all of the executive committee, from the training committee, and from everyone here for arranging all of it. Thank you, Dom.
Thank you very much. Thank you so much for attending.
Thanks. And finally, it's my deep regret to announce that our annual reception that we would normally have after has had to be canceled due to restrictions ongoing in the Netherlands. But I won't leave you without anything. I will leave you with a recipe for your evening. So all you have to do is get a vessel, any kind you like, anything, just something that'll hold some beverage. Fill it with your favorite sauce. This, leaded or unleaded, it doesn't matter. And then take yourself a comfortable seat. Think about the community that we shared today. And at that moment, we'll all be together. So with this glass, can I say, good night, good day, good morning. Joy be with you. Thanks, everyone. See you soon.
Bye, everyone.